Set date.
Number 42, needed? Okay. And this is the State of Texas versus Kewan White. Cause number F2500179. Good morning, ladies and gentlemen.
Good morning.
Thank you all so much for your patience. I know you've been waiting a while in the hallway. We've been working hard while you were out there waiting. So let me welcome you to the Criminal District Court number 7. This is a district court that handles felony cases ranging from low-level felonies all the way up to capital murders, okay? That carry a life or death sentence. Not to be confused with the County Criminal Court number 7. There are 2 court 7s in this building. One is a misdemeanor court on the 4th floor. That's the misdemeanor court. This is District Court number 7 on the 7th floor, okay? 7 on 7. And I'm telling you this so that when you go on your lunch break or bathroom break, you won't go to the 4th floor, okay? Some jurors get that mixed up. So this is court number 7 on 7. Before we continue, I'm going to give you all an oath. So if you would raise your right hands for me. Do you and each of you solemnly swear or affirm that you will make true answers to the questions propounded to you by the court or under its direction concerning your qualifications as a juror, so help you God? Thank you. So let me introduce the parties. We have, representing the state of Texas, Thomas Adams.
Good morning, ladies and gentlemen.
Crystal Diggins.
Good morning.
Ricardo Vela.
Morning.
And Marissa.
Good morning.
For the defense, we have Ms. Bree West.
Good morning, folks.
We have Myra McIntosh.
Good morning, everyone.
And helping them is Chilani Washington. I don't know if she's here today.
She'll be in this
She'll be
afternoon.
here this afternoon. And Mr. Kewan White is a defendant in this case.
Good morning. Good morning.
All right. And I am Judge Chica Anya, your presiding judge of the Criminal District Court number 7. Before I took this bench, I practiced in this building for over 20 years. So you can imagine that I know the attorneys on both sides, and most of the attorneys that practice before me. Both sides are very experienced attorneys, okay, top notch. So you can expect a good trial if you're chosen in this case, okay? Both sides are going to be professional, they're going to be respectful, and this process is going to go as smoothly as possible, okay? So look to your left and to your right at your new neighbors and see if you know anybody. Does anybody know anybody else? Okay, we have some takers. Okay, we have, is that juror number 1? Oh, number 2. Mr. Ray, who do you know?
Randy Smith.
Who?
Randy Smith.
Randy Smith? Okay, that's you in the back? And that's juror number 62? Okay, how do you know Miss Smith?
We've been friends for a long time.
Okay, you're not her boss or her husband?
No.
Or anything of the sort. Okay, well, let me ask you, if both of you were chosen to sit on this jury and hear this case, would you be influenced by Ms. Smith's reasoning or by her choices or her judgment?
Possibly.
Possibly? Okay. And, well, we need a definitive answer. Would you,
Yes.
you would? Okay. How about you, Ms. Smith? Do you think you'll be independent and come to your own conclusions and be objective about what you're hearing? Or would you be swayed by Mr. Ray's reasoning?
Mr. Ray's a good friend, but I would think for myself.
You would think yourself? Okay, thank you so much. Thank you for your candor, and this is the reason why we ask some of these questions. Sometimes we have family members, husband and wife. I've had an employees say to me, well, my boss is on here, I can't go against my boss. You know, we need jurors who will be able to form their own opinions and not be influenced by, anybody else. And, so it could be you, it could be anyone. So thank you for your honesty. Okay, we talking, please speak up because my court reporter needs to take down everything that you're saying, okay? So, anybody know anybody else on this side? All right. Before we get into the nitty-gritty of this process, this 4-hour process, I need to make sure that y'all are qualified to sit as jurors in Dallas County. The law requires that you possess certain qualifications, and so let me go ahead and do that. First of all, let me ask you, except for failure to register, are you a qualified voter in Dallas County? So even if you haven't registered yet, if you're a qualified voter, then you're qualified to sit as a juror in Dallas County. Is there anyone who's not a qualified voter in Dallas? Okay, we have some more takers. What's your number again?
70.
Number 7? And why are you not a qualified voter?
You just don't want to be.
Okay, I'm not talking about whether you want to be or not, but if you're able to, let's say you were, trying to register, would there be an impediment to that?
Religious beliefs.
Okay. But you're a qualified voter though, right? You can vote in Dallas County,
I
should
can.
you choose to,
I
is that
do.
right?
I choose not to.
Okay. And you, ma'am?
Just choose not to.
You just choose not to? Okay, not that you cannot, but you just choose not to. Thank you very much. All right, is there anybody else? Okay. Have you ever been convicted of theft or any felony? If you've been convicted of a theft or any felony, you're not qualified to sit on a Dallas County jury. So is there anyone who fits that bill? No hands. Are you under indictment or legal accusation or on deferred adjudication, which is a type of probation, for theft or any felony? So we're talking about theft or any felony. Are you under indictment, legal accusation, or the type of probation called deferred adjudication probation for theft or any felony? Anyone? No hands. Are you presently insane? According to you, not your family members or friends, according to you, presently insane, or have you been declared insane by any mental health or judicial official? If you have been, we need to know. Any hands? No hands. Are you 18 years of age or older? Is there anyone who's under 18 years of age? No hands. Are you a citizen of the United States? If you're not a citizen, maybe you've got your green card and you're waiting for your citizenship and you just haven't taken the oath yet, then you can't be on a panel. So is there anyone who's not a United States citizen? Okay, no hands. Are you a resident of Texas and resident of this county, of Dallas County? If you live in Denton County, in Collin County, any of those other counties, you can't sit on a Dallas County jury. So some people are confused. They, straddle county lines and they're not quite sure where they live. Is there anyone like that who's not sure which county they're in? Okay, so everybody lives in Dallas County, right? Okay. Are you of sound mind and good moral character? Again, according to you. Is anyone who's not of sound mind and good moral character? All right, no hands. Are you able to read and write the English language? Sometimes we have people who are not so, it's not their strength, the English language, and they're not going to be able to understand or follow what's being said. So if you struggle with the English language, we need to know. Yes, sir. What is your number? Okay, Jorge Ortega, number 24. Thank you, sir. Is there anyone else? Yeah, would you say your number, please?
49.
Okay, 49.
Writing,
Writing, okay. Do you read?
a little bit.
Okay, a little bit, okay. Do you understand what's going on? Yes, a little bit, or yes, a lot?
Yes.
You do? Okay, thank you. Okay, number 33,
Yes, ma'am.
that's, Ethan Bowe.
Yes, ma'am.
Okay, you struggle with the English language, sir?
Yes.
Okay, thank you.
You're welcome.
Okay, we have another hand, number 1.
Yes. I can read, but not too much, and I can speak better.
Okay,
That's it.
do you understand what's going on, what I've said so far?
More or less.
More or less?
Yeah.
Okay, thank you very much. Okay, number 56, that's Renee Velasquez.
Yes.
Okay, you struggle with the English language?
Probably understand half of what, talking about.
Okay, all right, thank you very much. Number 56. Did I miss anybody? Yes, sir, and that would be number 77, Mr. Antonio Lopez.
Yes, ma'am. It's not speaking English too much.
Okay, thank you very much. Anyone else? Yes, what's your number, sir?
87?
Number 27, and that's Alberto Fiscal?
Yes.
Okay, you struggle with the English language?
I read and write, but I'm not 100%.
Okay, all right, thank you. Is there anyone else? Okay, that's about it. Have you served as a petite juror for 6 days in the past 3 months in a county court, which is a misdemeanor court, or 6 days in the past 6 months in a district court such as this court? If you have, then it's too soon for you to serve again. So, anyone? No hands. Is there anyone who thinks that they're disqualified under the law for some other reason that I haven't mentioned? Yes, ma'am.
I work for,
I'm gonna come right there. This, I'm talking about disqualifications, not excuses. We haven't come to excuses yet. Okay, no hands. All right, the next script that I'm going to go over with you is the exemption script, okay? And if you fit under this part, you don't have to take it if you don't want to, okay? We would love for you to stay and be on this jury. This system can't work without you. So even though you may qualify under the exemptions, you don't have to take it. But if you do, we won't judge you, okay? It'll be your right to take the exemption, okay? We'd love to have you, but you don't have to stay, all right? So, are you 75 years of age or older? If you are, that's an exemption that you can take. We don't have to give you it. We would love to have you. Yes, number 53. You're 75?
Yes, ma'am.
Okay, would you like to stay or would you like to leave afterwards? You'd like to leave?
Yes, ma'am.
Okay. In due course, I'll let you leave, okay? That's an exemption. Thank you very much.
Donna, what number was that?
That was
53?
53?
Okay, thank you.
53, yes. This is a first. Usually we don't have 75 and older. But thank you for coming out, sir. We appreciate it.
Thank you, ma'am.
All right. Do you have legal custody of a child or children under the age of 12 years? And being here would mean leaving that child or children without adequate supervision. Now, this is one you need to take. Okay. Let's see, and that's Miss Vila.
yes, ma'am.
Okay, you have children under the age of 12?
Yes.
And are you the only
Right.
person who's watching? Okay, thank you. Anyone else? Would you raise your number for me?
38,
38? Okay, that's, let's see, Mr. Gloss?
yes,
Okay. You do have children under the age of 12?
out of 3,
3? And you're the only one who watches them
during the day, yes.
during the day? Okay.
Yes, my wife works at the hospital.
Okay, thank you. Number 52. That's Mr. Tips?
Correct.
Yes. What's your situation?
I have an 8-year-old son. My wife works, and my mom normally helps watch it, but she's
But she's what?
receiving cancer treatment.
Oh, okay, okay, I'm sorry to hear that. Okay, number 52. Anyone else? Okay, lower the hands. Are you a student in a public or private secondary school? If you are, you probably should be in school or getting ready. Don't need to be here. Okay, no hands. Are you enrolled and in actual attendance, not online, actual attendance at an institution of higher education? If you are, then you don't need to be here. It's an exemption. No hands. Are you an officer or employee of the Senate, the House of Representatives, or any department, commission, board, office, or other agency in the legislative branch of state government? Any hands? If you are, it's an exemption. No hands. Are you the primary caretaker of a person who is an invalid, unable to take care of himself or herself? Means they can't do the basic necessities of life for themselves, and you're the one who takes care of them. Yes, ma'am. Is that number 75?
Number 7.
Number 77. Okay. Thank you. Anyone else? Yes, what's your number, sir?
59.
59, Mr. Vang?
Yes, ma'am.
Yes, what's your situation?
My grandma has dementia, so I just have to take care of her.
Okay, are you the only one who watches her?
We switch off with my cousins.
You switch with who?
With my cousins.
Okay, so there's someone else who's, you're not the primary caregiver?
No.
Okay, thank you. Anyone else? Thank you. Are you a member of the United States Military Forces serving on active duty and deployed to a location away from your home station and out of your county of residence? If you are, that's an exemption. We thank you for your service. Any hands? No hands. All right, so that's the exemption script. Now we go over to the excuses, okay? And I have to tell you right off the bat that work is not an excuse. Otherwise, most of you won't be here, right? So work is not an excuse. The only reason that I would consider work as an excuse is number one, if you're the sole breadwinner for your family, and being here would mean a great hardship for your family. Okay? If you're the sole breadwinner, and being here would mean that your family will, suffer the consequences. There are consequences. So, is there anyone who fits that bill? If you are, then, that's an excuse that you can take. Okay? Any hands? No hands. The other excuse is if you're traveling and you have non-refundable plane tickets that you've already bought and you can't get, your money back, and you'll be traveling probably within the next 2 weeks. Yes, number 32?
I have that.
Okay, when are you traveling, sir?
Excuse me?
When are you traveling?
September 16th.
September 16th? thank you. What's your number again, please?
28.
28, thank you. Anyone else? Yes, what's your number?
35, but is
35.
this only for weekdays?
Yes,
Traveling?
it's weekdays, yes.
Never
We
mind.
don't work on weekends.
Just making sure.
The attorneys might, but. Okay. Yes, number 11?
I'm traveling to Houston tomorrow and returning on Thursday.
Okay, thank you. Anyone else? Number 16,
Traveling on Monday.
okay. Anyone else? Number 17,
September 7th.
September 7th? Just make sure they're with you, please. Anyone else? Yes, what's your number?
Number's 30,
Yes,
I'm traveling on Friday,
okay. When are you coming back?
come back Monday.
Thank you. Is there anyone else? Okay, so this, okay, what's your number?
40.
Number 40? Okay,
I travel for work, so are you asking days because we have to come back or?
yeah, what, the reason that I'm asking is that if you have, like, work is not an excuse, like I said, work is not an excuse, except for the circumstances that I described earlier. So my next question that I was asking was if there's anyone who's got non-refundable plane tickets and they're traveling between, now and 2 weeks. That was my question. Okay? All right. Is there anyone else who's got non-refundable plane tickets and they're traveling within the next 2 weeks? All right, and the reason I'm asking that is I anticipate that this trial may take 2 weeks, okay? So, if you're traveling within that time, then we need to know. Yes, 69?
Traveling on August 31st.
Thank you. Okay, the next question I want to ask everybody is there anyone who has any medical issues that will prevent them from being able to concentrate on testimony and be, engaged and involved in the trial process? If that's the case, we need to know. I mean, if you're on medications and you're managing it, that's fine. And if you need breaks, bathroom breaks or to stand up and stretch and whatnot, we can accommodate that. But if there's, if you have a medical condition that's going to interfere with your ability to concentrate on the trial, then we need to know. Yes, ma'am.
I'm breastfeeding, so I just need breaks to pump.
And that's fine.
I just wanted to.
If you want to be here, we'll love that. We need accommodation. Okay. Anyone else? Yes, number 37.
I have like ADHD, so I'm just not really, I always have to take like Adderall and stuff like that, but I don't have any of that currently.
Did you say you used to have or you
No,
have?
I do.
You do? Okay, so you think it'll affect your concentration?
Oh, 100%.
Yes, okay. Thank you, appreciate that. Anyone else? Yes, ma'am.
I have stage 4 kidney disease and that goes to the bathroom a lot.
Okay. Okay, thank you. We can accommodate that if you
Okay.
want to say, okay? Thank you very much. And that's, juror number 75. Thank you. Is there anyone else? Okay. Is there anyone who thinks that there's a situation that pertains to them that I haven't covered? Yes, sir, number 13.
My mom has surgery tomorrow, and I take her and discharge her on Thursday.
Okay, thank you, number 13. Anyone else? Yes, what's your number?
Number 8.
Number 8, yes.
I'm contracted, I don't have any PTO, and I take care of my children by myself, so I'm afraid if after this 2 weeks, because if I'm not in the building, I don't get paid.
Okay. Okay. So you're the only breadwinner for your
Yes,
children?
ma'am. I don't receive any child support or anything.
Okay, thank you very much. And that's your number 8, Ms. Phillips?
Yes, ma'am.
Okay, thank you. Anyone else? Yes, what's your number, sir?
19.
Number 19?
My wife's not employed, I'm the only breadwinner in my house,
Okay,
and she's been unemployed for a little bit, so.
okay. Thank you. And that's Mr. DePetris?
Correct.
Thank you. Number 48.
Yes, ma'am. My wife is traveling next week for work, so I'll be the only person home with my kids.
Your wife is traveling next week for work?
Yes, ma'am.
Okay. Say your number again?
48?
48, thank you. So I guess this will be childcare issues, right?
Yes, ma'am.
Okay, did I miss anyone? Number 29.
My wife travels to work as well. I have to pick up my son by 5 o'clock when he gets here.
Okay. Your wife travels out of county
Yes.
for work? Okay. And you have to pick up your child by 5 every day?
5 every day.
I think you'll be fine. By 5?
Yes.
Okay. We'll pretty much be done before 5 daily.
Okay.
So will that work for you?
I would need to be there by 5 or
By 5? Okay. Thank you. What's your number again?
29.
28?
29.
Sorry, 29. Okay, that's Mr. Bordelon.
What a lot.
Okay, thank you. Okay, did I miss anyone? Yes,
Yeah,
what's your number?
40.
Okay.
I just really want to understand how it works. I don't have an issue being here for 2 weeks, but I need to understand what happens to my job or how it's been protected. I'm a flight attendant and you can come in tomorrow to be in China. I have to. So that is why I was concerned. I was asking earlier. I don't mind being here if I have something to send them, I have to be here.
Yeah, the bailiffs will give you something to show your job. Okay? All right, thank you. Okay, if there are no other hands, let's go into some of the things that you will be hearing. So, as I said before, just a little bit more about me. Before I became a judge in this court, this is my 8th year on the bench. I practiced in this building for several years, over 20 years. I'm also board certified in criminal law by the Texas Board of Legal Specialization. I've been married for 34 years to my husband. He's also an attorney, practices in this building, but not in this court, lest I hold him in contempt. But yeah, it's just to avoid the appearance of impropriety. It's a rule that we go by, ethical rule. And I have 4 adult children, 3 sons who are all graduates of the Texas A&M Dwight E. College of Engineering. Graduated several years ago. My daughter thinks that she's more intelligent than they are, smarter than they are. She was actually her high school valedictorian and continues to, maintain her A streak in college. And so I'm very proud of who they are. And so the purpose of this portion of the trial, which is called voir dire, is so that both sides get to know you and what you think, okay, about the issues that may arise in their cases, okay, the state and the defense. And honesty is all both sides want. Honest answers, okay? There's no right or wrong answer. how you feel. We're not here to judge you. We're here to understand how you feel about the system, about this type of case, and if you will be a fair juror. This is the type of case that you can sit on and be a fair juror. So, Mr. White is charged by indictment with the first-degree felony offense of capital murder by remuneration or the promise of remuneration. Does everybody understand? Yes? I'm gonna need y'all to let me know that you're still engaged. So the range of punishment for this offense could be automatic life in prison or death. However, the DA's office is not seeking the death penalty. Okay? So if you find Mr. White guilty of this offense, I will have to impose an automatic life sentence without the possibility of parole. Okay? So he's charged with capital murder for remuneration or the promise of remuneration, and the range of punishment is automatic life in prison without the possibility of parole. That's the case that you're here about. Okay? And as I said, the purpose of Rodai is to make sure that we have jurors who will be fair, who will be objective, who will concentrate on the testimony and the evidence that will come from this witness stand and nothing else. And that leads me to the publicity that's surrounding this case. This is a high-profile case. The media has been all over it. There have been, videos shown, articles written, bloggers and whatnot. And so I'm sure some of you have seen it, have heard about it, or seen it. Okay? But that's really not the issue. The issue is, having seen it or heard anything about it, can you remain objective and wait till you hear the evidence from the witness stand? Because y'all, whoever's chosen to sit over here, y'all will have front row seats to what actually happened. You'll hear from the witnesses, okay? You'll hear from the state as to what really occurred. So all that stuff in the media, that's not what you need to think about. Does everybody understand? So both sides are going to ask you, and I'm asking you, if you can remain objective and not let whatever you've heard already influence your decision or your mind. Because if you've already made up your mind before you've even heard the evidence, the real deal from the evidence, then you're not a good juror for this case. You won't be a fair juror. Okay? Does everybody understand?
Yes.
Okay, so because that question is going to come up, all right? So let me ask you generally, can you all promise me that you will not allow anything that you have heard outside this courtroom influence you if you are chosen as a juror?
Yes.
Can you promise that?
Yes.
Raise your right hand. Okay, if you cannot promise, leave your hand up. Anyone? Okay, because that's very, okay. All right. Hold on. Okay, number 25. So you've heard stuff about this trial and this case, and you don't think you can be fair, is that right?
That is correct.
Okay, thank you very much. You've already made up your mind, and you're not going to wait to hear the evidence. Okay, thank you. Thank you. Who else? Say your number for me.
30.
Number 30. And what's your position? I need you to articulate what you're trying to tell me.
This gained my interest, I've read a lot about it, and I'm not 100% certain I can be objective.
Okay, thank you very much. Number 44.
Yes, ma'am. I've seen the videos. I would like to say I could make the promise to you, but I'm not sure I can.
But you're not sure? Okay, I'm hearing I'm not sure, I don't know, but, in this kind of trial, we need definitive answers. We need you we have a flight attendant here. So, let's say you were boarding her plane, okay, with her pilot, and you're going to Washington DC, and you ask the pilot, do you think you can land this plane safely in DC? And he says, well, I'm not sure. Would you get on that flight? Would you get on that flight?
No, ma'am.
No, right. So that's the kind of answer that we need, because if you end up over here, and it's too late, for you to change your mind or anything, and both sides need jurors who, are sure about what they feel and what they want to do. So the question is, do you think will you be fair or not?
No, ma'am.
No, thank you very much for your honesty. And that was number 30, is that right?
I'm sorry?
What was your number again?
44.
44? That's right, sorry. Number 25, let me come back to 25. 25, is that still your answer? No? Okay.
Yes, the answer's no.
All right, thank you. And number 30?
Same answer.
Same answer, thank you very much. Okay, who else? Let's see, 43?
Yeah, I'm not able to.
You're not able to? Thank you.
I know personally,
Okay,
so.
thank you, I appreciate that. Number 65?
Yeah, I'm somewhat familiar with the case, and I have some family members and friends who are familiar with some incidents.
Okay. So you will not be fair? Thank you, I appreciate that. Who else? Okay, number 22? Can you speak up for me, please?
Yes, I will not be fair.
Okay, thank you. Anyone else in the back?
Right.
What's your number?
Number 58.
58?
Yes, ma'am.
Okay, you've heard about this case in the media and you won't be fair.
Yes, one of those.
Okay, thank you. Anyone in that far corner? How about over here in the comfortable chairs? Anyone? Y'all may end up being our jurors. All right. All right, so, and I have to instruct you all, okay? Even those of you who've already seen it and, who know a little bit about this case, going forward and until this case, this process is over, I'm instructing you not to go on social media, do any sort of research, look up the defendant's name, or anybody else in connection with this case, okay? Because we need to stem that tide and not pollute everybody's mind about, what happened or what may not have happened. Because if you do, that has consequences, including the fact that we will have to start this all over again, and that's a waste of your time, taxpayer money. Does everybody understand?
Yes.
Those of you who have heard about this case or read about it, you are not to discuss it with any other juror. Do not pollute the panel. So don't talk to each other about this case. Don't talk to your significant other or to your spouse or your friend. You can tell folks that, yes, I'm doing a jury duty today, but don't discuss the case, the facts, or try to find out anything else about what happened. Does everybody understand?
Yes.
That's my standard instructions to you until you're released from duty, okay? Okay. So, the trial process of which this part is the first portion. So after this portion, when we have selected 12 individuals who will hear this case, the indictment will be read. The defendant has entered a plea of not guilty, okay? So the state will have to present evidence and prove each and every element of this offense to you beyond a reasonable doubt before you can find the defendant guilty. The state has the burden of providing all the evidence. The defense doesn't have to do anything. Just by being here, they've done their part, okay? Because he who brings the charges must prove it. So, after the guilt or the innocence phase, which is when the state puts on their evidence, I will give you a charge, a jury charge. You're the ones who need to listen carefully to the facts coming from the witness stand, because you're the jurors, okay? You are the fact finders. I'm the lawgiver. I give you the charge and the law that guides you during your deliberations, okay? So, when I give you the charge, at the end of the case, the guilt or the innocence phase, send you to the jury room to deliberate guilt or innocence. If you find the defendant not guilty, that's the end of it, okay? Everybody goes home. If you find the defendant guilty, then I will have to impose an automatic life sentence without parole. So that's how that part, the guilt or the innocence part, will go. Does everybody understand?
Yes.
Now, unless there's a lesser included offense that the state proves or that the evidence brings forth, okay, there will not be a punishment phase, okay? So for example, this is a capital murder. A lesser included of capital murder is murder, and it carries a different punishment range from a minimum of 5 years up to a maximum of 99 years or life in prison. Not automatic life in prison like the capital murder. Does everybody understand so far? It's a different range of punishment. So if that happens, then there'll be a third phase of this trial, which is the punishment phase, okay? And I will give you a charge, letting you know what the punishment range is, and the law that will guide you during your deliberations, and you will have to consider that range of punishment. And I know the parties are going to talk to you about the punishment range. Does everybody understand? And what they'll be asking you to do is to consider the entire range of punishment. Nobody's asking you to commit. A fair juror is one that's going to be open-minded and wait to hear all the evidence. Because right now, y'all don't know anything, right? Except maybe what you've heard in the media. You haven't heard any evidence yet. So if you can keep an open mind and wait till you hear everything and decide whether, you know, the evidence has swayed you to such an extreme that you want to give that automatic life in prison and a conviction, then, you know, that's fine. But if the evidence sways you to give him the lower end of the punishment range from 5 years, you know, anywhere in the middle, all the way up to 99 years, then that's fine too. But you have to allow yourself the opportunity to hear the evidence first, right? Does everybody understand? Is everybody on board?
Yes.
Is there anyone who says, no, I'm not gonna wait, you know, if I convict him, I'm not gonna, you know, want to know anything else, it's just gonna be the high end. Is there anyone who feels that way? The parties are going to ask. If you do, then you're not going to make a fair juror. That means you can't follow the law, okay? If you want to be on this panel, you have to be able to follow the law, set your personal feelings aside, and be objective. Does everybody understand?
Yes.
Okay. So that's the trial process in a nutshell. And your function, like I said, is to be fair, to determine the facts. You're the fact finders, okay? You're the ones who will listen to all the evidence presented and weigh the credibility of the witnesses, okay? So how do you weigh the credibility of witnesses? You listen attentively to what they're saying. You ask yourself, were they there? Did they hear what was said? Does their testimony make sense? Does it contradict anything else that I've heard so far? Okay? Just the same way that you judge the credibility of folks in your life, your coworkers, your children, your spouse, your friends, the same way. You wait till they tell you what it's about before you determine whether you believe them or not. Does everybody understand?
Yes.
Does everybody agree?
Yes.
Yes. So just because a person is a police officer or a pastor or a nurse or a doctor doesn't necessarily mean that they're credible, right? That they're truthful. Because folks wear a collar and get on that stand and tell lies, right? Does everybody agree?
Yes.
Yeah, so you can't judge a book by its cover. You have to wait until you hear the testimony and then decide whether they're being truthful or not. So is there anyone who's going to ascribe a greater credibility to a certain type of witness? Let's say a police officer or a lawyer, you know, or someone. Anyone? So you will wait. Okay, go ahead, ma'am.
I would to a police officer.
You're married to a police officer?
No, I would give more credibility to a police officer.
Okay, what's your number?
41.
Number 41? personnel in, high regards, now and then, even though they're just like everybody else. They make mistakes, there are great ones amongst them, and then there are bad ones amongst them, right? So are you saying that even before they testify, that you will ascribe credibility? Or you will not wait till they testify, you're just going to believe whatever they say?
I guess I would wait till they testify, but I would.
Yes, because it's a little confusing, right? I'm not asking about your general perception of the police. I'm just saying, in this trial situation, are you going to wait till you hear what the officer says on the stand? Or are you going to say, oh, he's an officer, I'm going to, believe whatever he says, even before he gets on the stand? That's the question.
I would,
I'm sorry?
I would listen to what he has to say.
You would wait and judge his credibility then, is that right? Okay, thank you very much. So did everybody understand her response? Okay, is there anyone who feels differently about a certain type of witness? Number 73?
I mean, if someone's credentialized, like a ballistics expert or something like that going on the stand, I would think that their expert witness testimony has a little bit more credence than maybe someone in the general population.
Okay, if it's an expert witness, right, in their field, yeah, and that's good. Okay, anyone else? But you will wait, you will hear their testimony, right?
I would hear it for sure, yes,
Okay,
but
and-
it would be naive of me to say that I wouldn't be automatically assuming them to be more truthful than anyone else.
Okay, if they're an expert.
If they are being called as an expert
Okay.
witness, I would
Okay,
likely believe them to be more truthful than anyone else.
okay, thank you. Anyone else? Okay, so everybody understands that. You place everybody on the same level, the same pedestal, and wait till they testify before you ascribe credibility. Okay. All right. And the state brought these charges, and there are elements that they have to prove to you beyond a reasonable doubt before you can find Mr. Wyatt guilty. Okay, some general principles here. They have to prove to you that a murder was committed, capital murder. Someone was killed in Dallas County. Okay, someone was killed for remuneration, for the promise of remuneration. Number two, that it happened in Dallas County. Otherwise, I wouldn't have jurisdiction. They have to prove that it was in Dallas County. Okay? Number three, that it happened on or about a certain date, which was before the return of the indictment. Okay? And number four, that it was the defendant who committed it. They have to prove these four basic elements to you beyond a reasonable doubt. Otherwise, your verdict will have to be not guilty. Does everybody understand?
Yes.
Okay, now there's other specific things that the state would have to prove to you in addition, but these are the basic ones that they have to prove. And if they can't prove any one of these, your verdict must be not guilty. Okay? Is there anyone who cannot follow that? All right, number 25 had his number up.
Yeah, Paul, I just had a question. You mentioned remuneration or remuneration?
Remuneration, yes.
I don't know the word, I'm sorry.
Okay, all right, well, I'm glad you asked, thank you. If there's anybody who doesn't understand anything I say, just raise your hand and I'll explain it to you. Remuneration means for payment, murder for hire. Okay?
Thank you.
So the promise of payment, either they got paid or they were promised a payment. Does everybody understand?
Yes.
That's what this capital murder is about. Capital murder for remuneration or the promise of remuneration, okay? All right, and so I just told you what elements the state has to prove to you. And the burden of proof in the criminal case is beyond a reasonable doubt. It's the highest burden in our justice system. And that's because someone's freedom is at stake. And that burden remains on the state all through the trial. It never shifts to the defendant, okay? So for example, the state may bring on evidence, and at the end of the day, you think to yourself, well, wow, I would have loved to hear this about this, or, maybe if the state had brought me this, that would have helped me come to a verdict. You can't look to the defense. You can't say, I wish the defendant would have, supplied the missing link. You look to the state And if they leave you with a reasonable doubt about Mr. White's guilt, you have to find Mr. White not guilty. Does everybody understand? The state must prove it to you beyond a reasonable doubt. And we're not allowed to define beyond a reasonable doubt to you anymore, because the legislature, took that ability away. But I can tell you that it's to your level of believability, right? And everybody has that threshold. So whatever it takes to convince you to your level of believability that Mr. White committed this offense, that's what it is. Okay? Does everybody understand?
Yes.
Okay. And like I said, that burden never shifts to the defendant. You don't look to the defense to supply any missing links or any reasons that you have. Okay? Mr. White is accorded the presumption of innocence under the law. He is presumed to be innocent unless the state proves otherwise. Does everybody understand that?
Yes.
That's the law, and you have to be able to follow the law. So, some of you, when you entered the room this morning, okay, and saw everybody standing here, you may or may not have known who the defendant was, but the question in your mind should have been, I wonder what he's charged with, and not, I wonder what he did. Do y'all see the difference? The different mindset? I wonder what he's charged with, not, I wonder what he did. Because you haven't heard anything yet. And people get indicted, okay, get charged with offenses. They have a jury trial and they get found not guilty, right? Have you all heard of folks getting found not guilty? Yes? So it happens, right? So he's innocent unless the state proves to you otherwise. So let me ask you all then, is there anyone who feels that the defendant should not be accorded that presumption of innocence just because he's here? Can everybody follow the law? And hold the state to their burden to prove this case to you, to your level of believability? Yes? Okay. That takes me to the indictment. So Mr. White is here on an indictment. Okay, that's how felony cases are charged, by indictment. So the indictment is just a piece of paper that tells the state what they have to prove to you beyond a reasonable doubt, the elements that they have to prove to you beyond a reasonable doubt. The same document that tells Mr. White what he's charged with. It is not evidence of guilt. Does everybody understand? Yes? An indictment is not evidence of guilt. People get indicted, they get charged, they go to trial, they're found not guilty. So it's not evidence of guilt. And that's very important that you not hold it against Mr. White as evidence of guilt. Is there anyone who feels that because he was indicted that he must be guilty? Anyone? So y'all promise that you will not hold it against Mr. White that he was indicted for capital murder. Is that right?
Yes.
You will wait and hear all the evidence before you decide if he's guilty or not, correct?
Yes.
All right, thank you. All right. The last thing I want to discuss with y'all is the defendant's right to testify. Have y'all heard about the Fifth Amendment right to remain silent? Yes? In a trial situation, the defendant has a right not to testify. Okay? So, I don't know if Mr. White's going to testify or not, but all I know is that if he chooses not to testify, y'all cannot hold it against him. That means he's exercising his right under the law. Could be that his attorneys have advised him not to testify because maybe they feel the state hasn't proven the case beyond a reasonable doubt and they don't want Mr. White badgered on the stand for no good cause. It could be that Mr. White, when he gets on the stand and opens his mouth, he's arrogant, gets arrogant. And y'all will hate him just for being arrogant, right? And feel, oh, he must have done it because he's arrogant. Or maybe he's timid and he gets on the stand and he smiles awkwardly or, does quirky movements, and then y'all dislike him even more and say, oh, he's weird, he must have done something. I mean, there's a number of reasons why a person may decide they don't want to testify. Not everybody, is given to speech, right? Is that right?
Yes.
Okay, so if he does not testify, you cannot hold it against him, and you can't wonder why he didn't testify. Can everybody promise that they will not hold it against Mr. White if he chooses not to testify? Yes? I mean, it's normal for us to want to hear both sides, right? That's natural. But we're not talking about your everyday life here. This is the legal system, and the law says that he does not have to testify. So to be a good juror who can follow the law, you have to be able to respect that. So is there anyone who says, if Mr. White does not testify, I will hold it against him, or I'll be biased against him for that reason? We need to know. Both sides need to know, okay? Yes, sir. What is your number again?
58.
58? Thank you. Anyone else? What's your number, sir? 19? Thank you. Anyone else? Okay. All right, so I believe that concludes my portion of voir dire. Let me ask you all, does anybody need a bathroom break before we continue, or the lawyers are saying we need a break? Okay, so let's take a 10-minute bathroom break and be back here at 10:15. Few more minutes. Wait in the hallway, and the bailiff will bring you back in. Look to your left and to your right so you remember where you were seated. And do not discuss with the press or anybody else. You remain under my instructions. Ladies and gentlemen, please look to your left and to your right and see if your neighbor made it back. Everybody here? Okay. All right, before the break, I concluded my portion of voir dire, and it's time for both sides to talk to you, beginning with the state. And from time to time, I will interject just to clarify some questions, okay? Because sometimes a juror or jurors might not understand what's actually being asked and will inadvertently remove themselves from the panel. So I'll explain from time to time just to make sure that everybody understands what's being said. Okay? Does everybody understand?
Yes.
All right. Is the state ready to proceed?
State's ready, Your Honor.
All right, go ahead.
May it please the court? Counsel? Good morning. All right, that was actually pretty good, but I'm gonna try it again. Good morning.
Good morning.
All right, my name is Crystal Biggins. Judge briefly introduced me. I am a prosecutor with the state of Texas. I have been a prosecutor for about 17 years. I started my career in Brazos County. If anybody knows where Texas A&M is, I started down there. Went to the Texas AG's office, and then I've been with Dallas County since about 2013. So, anyways, I tell you guys a little bit about myself because we are going to spend the next hour and a half, hopefully I'll give some time back to you guys. And I've had an opportunity to look through some of y'all's file forms as well as questionnaires. And so we're gonna kind of talk about some of the things that you all put down. Also,
Okay, Ms. Biggins.
yes,
Let me jump in here, okay? So y'all, ladies and gentlemen, y'all filled out questionnaires, okay? And I want to tell you that even though you put certain things down on the questionnaires, answered some questions in a certain way, but sometimes, you know, when you, after you hear both sides and what this case is all about, you know, sometimes you might change your opinion or your answers. Does that make sense? So if that is, you know, if that's the case, make sure you tell the attorneys, okay? And it's okay for you to change your position based on what you hear, because we're humans, and sometimes, you know, depending on what's said and what's heard, you might change your opinion. So just to let you know, that's not in stone. If you need to change your mind about something, let the parties know. Thank you. Go ahead, Ms. Biggins.
thank you. And so I'm basically telling you guys a little bit about me because I've gotten to learn a little bit about you guys. And so I was born and raised here in Dallas and went to school in Houston, moved away, lived in Michigan. I went to law school up there, and then I went to New York and did entertainment law there and decided that reading contracts was quite boring. And so I came back and I've been doing criminal law since then. Anyways, I would like to give you guys some kind of housekeeping matters and kind of take care of some of this stuff. But one of the things I want to know is who is happy to be here? Oh, wow. That's actually shocking. I'm glad that we actually get some hands. I will tell you, I have always wanted to sit on a jury. I am never going to be picked for a jury, or because as soon as they find out that I'm a lawyer, I'm gone, right? And so thank you guys for wanting to be here, but honestly, thank you all from both sides. I've known these ladies and this team over here on the defense for a very long time, and I will tell you that we are grateful for all of you all who have shown up, because this is an important process. This is something that we take very seriously. We will at times kind of be lighthearted. I don't want you all to think that at any point we are taking away from how serious this is for both the state of Texas, for Mr. White and his team, also for our victim's family, okay? It's hard to sit here and listen to law for an hour and a half, I'm just gonna be honest with you. But here's a secret. For all of the rest of you all that did not raise your hands, the 70 plus of you all who did not raise your hands that are happy to be here with us, the quieter you are is the more likely you end up on a jury. Who knew that? The quiet ones. How did you know that? You are juror number 35?
I just guess,
Oh.
if you don't have strong opinions, and
One
you
way
don't
or the
voice
other.
your opinion, then, yeah.
Yeah, so what I like to give juries a little hint that you all aren't talking to me or being responsive enough for us to kind of know about you one way or another. I like to walk over here to where these comfy seats and kind of put my hand over here. So if I'm over here standing like this is where you're headed if you're not being responsive. Everybody understand? All right, y'all are comfortable over here, right? These seats are quite comfortable. Juror number, you are juror number 72? You don't want to, you're like, I don't want to, y'all can have her seat, is what she's saying. Anyways, I do want to apologize in advance for having my back to you all. This is kind of like at SeaWorld. I took my kids to SeaWorld a couple of years ago and saw Shamu. Anybody familiar with? Okay, all right. I didn't know if I was really dating myself or SeaWorld is not just really a thing here. But my kids wanted to sit in the front, because what happens in the front, juror number 5?
Splash zone.
Splash zone. All right, so the first 32 of you all are in the splash zone right now, okay? And so this is technically like a deselection process, rather than we pick you, that kind of thing. It's a deselection process. Anyways, so we are in this first stage of trial. Trial has begun, and this is called voir dire, what Judge explained, jury selection. The oath that you all took, which the judge had you all raise your right hand, it is just to tell the truth, to be honest with us, because this is important for, like I said, the state, the defense, the victim's family, and honestly, us as a community, because we want to make sure that we get 12 fair and impartial jurors that can listen to the facts and apply those facts to the law. Does that make sense to everyone?
Yes.
All right, because in order for this process to work, we will all agree, and I hope that we agree, that we need to make sure that everyone's rights are protected, specifically Mr. White's rights, correct? Yes. In addition to, we want to just make sure that our system works as a whole. And that means holding the state to prove our case to you beyond a reasonable doubt. That makes sense? That is a burden that we have. That is the burden that we accept. That is what we intend to prove this case to you beyond a reasonable doubt. And we will continue to talk about kind of what that means as we go on. But I want you all to know that in order for this process to work, this is the time for you all to be open and honest about your feelings. If you like the law, don't like the law, you wish it would change, whatever that feeling may be, this is the time. Because once you are over there, if you are selected, the thing is that it's too late. At that point, you will be required, in fact, you'll take another oath that says, I am required. The judge will instruct you to follow the law. And that means that in the event that the state, which we do intend to prove, this case to you beyond a reasonable doubt, and if we prove it beyond a reasonable doubt, what will happen is you will be required to find the defendant guilty. Make sense to everyone? Yes. All right, so everyone agree that we can have an open and honest and candid conversation about the law. If you like it, you don't like it, if you think that this wouldn't be a good case or any of those things for you. Everybody agree to be honest with me?
Yes.
All right. So the next stage, as the judge explained, is guilt innocence. At that stage, if you are selected, that's when you find out about the facts and what happened and what is alleged, right? We have alleged capital murder in this case, and we're going to talk about that. The third phase would be the punishment phase. However, I have an asterisk by it because technically, if we prove to you beyond a reasonable doubt that it is capital murder, the automatic punishment is life without the possibility of parole. And when we're talking about capital murder, there's typically two punishments, right? It's either we are seeking death, which the judge has told you, and I can tell you we are not seeking that. And then the other option is life without the possibility of parole, okay? That is sometimes really heavy. It's sometimes, things that people have to think about. People have strong feelings one way or the other. And as I explained to you all, with capital murder, if the state proves this case to you beyond a reasonable doubt, and you believe it beyond a reasonable doubt, you will be required to find the defendant guilty of capital murder. Does that make sense?
Yes.
All right. So I'm going to ask you all, because one of the hardest things sometimes is for people to understand that when we charge capital murder, you don't necessarily get to go to that third phase, the punishment phase. You don't get to know about the defendant's background and history and all of those things. It is based solely off the facts of the offense, whether or not the state proved this case to you beyond a reasonable doubt, okay? And if you believe it, then you will be required to find the defendant guilty of capital murder. Now, I know you all see the defendant sitting here, Mr. White, and we want to make sure that his rights are protected. So I'm going to ask each one of you to search your heart, your feelings, all of those things. If the state proves to you beyond a reasonable doubt that this defendant committed capital murder, and you believe it, can you find the defendant guilty? And I'm gonna start with juror number 1. Have you been, and before I ask that question, I'm sorry, have you been understanding everything we're talking about so far?
Most of it.
Okay, all right, awesome. So my question to you is, if the state proves to you beyond a reasonable doubt that this defendant committed capital murder, understanding that you may not know anything about his background or any of that information, it's just based off the facts of this offense. If we prove this case to you beyond a reasonable doubt, and you believe that we've done that, right? The question is whether or not you could find this defendant guilty of capital murder.
Yes, I would.
All right, thank you. Juror number 2. No? Okay. I think we have you. So if we have you for something, I may just kind of skip over you. Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
Juror number 7?
Yes.
Juror number 8?
Yes.
Juror number 9? Juror number 10?
Yes.
Juror number 11?
Yes.
Juror number 12? Juror number 13?
Yes.
Juror number 14? I'm sorry? Okay. Juror number 15?
Yes.
Juror number 30? Juror number 29? Juror number 28? You seem like you hesitated a little bit, and that's okay.
And can you all speak up just a little bit so my reporter can get you? The punishment would be. So even if, and let me make sure, and I don't want to put words in your mouth, but it sounds like you have an issue with the automatic life without the possibility of parole. Is that correct? So even if we prove this case to you beyond a reasonable doubt, you would have a hard time with assessing guilt because of the punishment that comes along with it. Okay. All right, let me explain something to y'all as well. You know, I'll be the one imposing that punishment, not you, okay? So what the state is asking you is, if they've proven the case to you beyond a reasonable doubt, which is to your level of believability, would you be able to find him guilty? Okay? Well, I guess on the other hand, knowing that I would impose that punishment, not you necessarily, but can you convict him after the state has proven to you that he's guilty beyond a reasonable doubt? That's really the question.
Yes, it would just be hard.
Okay. And when you, Judge, may I proceed?
Yes, you may.
Okay. And when you say it would be hard, basically you would have a hard time determining the guilt or innocence because in the back of your mind, you're thinking about what the punishment would be. Is that fair? Is that a yes? Okay, thank you.
What's your number again?
28.
Thank you.
Juror number 27?
Yes.
Have you been understanding everything so far? Okay. Juror number 26?
Yes.
Juror number 25, I think we have you. Juror number 24, have you been understanding everything that's going on? Okay, all right, I think we have you. Juror number 23?
Yes.
Juror number 22, I believe we have you, but I just want to make sure that you did previously say that you couldn't be there because of the outside information. Is that
That's
correct?
correct.
Okay, thank you. Juror number 21? Juror number 20?
Yeah.
Okay. Juror number, I'm gonna skip over you, juror number 19, juror 18?
Yes.
Juror number 17? Yes, all right. I'm gonna skip over you, 16, 31?
Yes.
Okay. Juror number 32?
Yes.
Juror number 33, have you been understanding everything so far?
Yeah,
A little bit, okay, kind of here and there, all right. Juror number 34?
Yes.
Juror number 35?
Yes.
Juror number 36? Juror number 37?
Yes.
Juror number 38? All right. Juror number 39? Does everybody understand my question? Remember my question? All right, I'm gonna ask it again just to make sure. If the state proves to you beyond a reasonable doubt that Mr. White has committed the offense of capital murder, and you believe it beyond a reasonable doubt, understanding that you may not know anything about his past or anything like that, and you see him, would you be able to find him guilty of capital murder? Juror number 40? Okay. Juror number 41?
Yes.
Juror number 42?
Yes.
Juror number 43?
No.
All right, thank you. Juror number 44? Juror number 45? You seem hesitant. This is the time.
I can't get my words out.
It's okay. Is this emotional for you?
Yeah.
Okay, I'm sorry. I'm sorry. If we need to talk to you at a different time, we can. Okay, thank you. Juror number 46?
Yes.
Juror number 47? Yes. Juror number 48?
Yes, ma'am.
Juror number 49, have you been understanding everything that we discussed? Okay, all right. Juror number 50?
Yes.
Juror number 51?
Yes.
Juror number 52? 53?
Yes.
All right. 54? I think 53, you're not gonna be with us anyway. You said you were gonna take your exemption. All right. Juror number 55? All right, thank you. Juror number 56, have you been understanding everything that I'm talking about so far? Okay, and what's your answer to my question? All right. Juror number 57, excuse me. Juror number 58?
No.
Thank you. Juror number 59?
No.
Thank you. Juror number 60? Juror number 61? Juror number 62? Juror number 63? All right. Juror number 64? And juror number 65? I believe we have you. Juror number 66?
Yes.
67?
Yes.
68?
No.
No? Okay. 69?
Yes.
70?
Yes, ma'am.
All right. 71?
Yes.
72? Okay. 73?
Yes, but I have concerns about personal safety given the stature of this case.
Okay, alrighty, thank you. Juror number 74,
Yes.
juror number 75,
Yes.
and then juror number 77.
He has me.
Okay, got it, thank you. Alright, so when we talk about, capital murder, in each case, the state has an indictment, and an indictment basically puts the defendant on notice on what the state has to prove. Does that make sense? It's a piece of paper that says, hey, this is what we've alleged that you've done, and he gets that and is noticed. Does that make sense? In that, it lays out the elements that we have to prove in order for you all to be able to make a determination of if we prove this case to you beyond a reasonable doubt. I like to think about these elements. Do I have any bakers? Okay, juror number 5, if you miss ingredients, right, does the recipe come out great?
No, probably not.
Okay, all right. So these are kind of like the ingredients, right? These are things that we have to prove in order for us to prove the case to you beyond a reasonable doubt, in order for him to be convicted. Those elements are on or about a certain date. Dallas County, Texas, that it happened here, kind of what Judge has already told you all, that this defendant is the person that did it, intentionally or knowingly caused the death of an individual by shooting deceased with a firearm. Defendant caused the death of the individual for, and when we're talking about capital murder is basically murder plus. There are several different ways in which we can allege capital murder. Sometimes it's murder and then plus a robbery, right? So we've kind of heard of people who go into convenience stores. Oh, I'm sorry. People who go into convenience stores, rob the store and kill the clerk, right? That would be a capital murder. We have alleged this capital murder by remuneration. And we're gonna talk about it. But basically, we have two ways in which we can prove this element, that the death of the individual was, that happened for remuneration or the promise of remuneration. Does that make sense? All right. Remuneration is a hard word for me, y'all. I'm just gonna tell you, I struggle with it, and I'm practicing, and so it's kind of hard. But when we talk about it, what that means, and I'm gonna go back to that, but it means a murder that occurs to receive remuneration is a benefit or reward, i.e. money, right? Payment in exchange for service, or murder that occurs on the promise of remuneration, right? So it can be either or, right? That makes sense so far? All right, everybody understand what murder is? All right, so let's say I'm gonna use some hypotheticals because we can't give you the facts in this case. I have to use hypotheticals. Let's say me and Mr. Adams, he brought me into this case, I don't like him anymore, I decide that he's gotta go. I pull out a gun, I shoot him in his chest, and he dies. Have I committed an offense, juror number 3?
Yes.
What offense have I committed?
Murder.
All right, juror number 4, you agree with him?
Yes.
Okay, now, juror number 4, let's say that this time, I know that Mr. Adams may be on to me, that I don't like him, and this time, I'm going to ask Marissa, raise your hand. I'm gonna ask Marissa to get rid of Tommy for me, because why would I do that, juror number 4? Why would I even ask her that?
Because you're trying to have someone else do it so you don't get charged.
Okay, did everyone hear that? I'm trying to have someone else do it so that I don't get charged. Juror number 5, do you agree with that? That thought process?
Well, yeah, sort of, or you said he was onto you, so maybe you were trying to surprise him or something.
Okay, all right, so in this hypothetical, let's say that I tell Marissa she's been eyeing this new Louis Vuitton bag, and I say, Marissa, look, if you can just kind of handle this for me, I am going to give you a new Louis Vuitton bag and $5,000, right? And she says, bet, got it. And so what she does is she then sees Mr. Adams, she sees Tommy coming out of the parking garage, she takes out her gun, she shoots him, and he dies. Juror number 5, have I committed an offense?
You personally or Marissa? You personally?
Me.
I guess indirectly, yeah. You have to be accomplice, right, somehow?
Okay. Do you think,
Okay.
has
I'm not
Marissa
a
committed?
lawyer, but yes, she did.
Okay, tell me what offense she committed.
Murder.
Okay, and why did she murder?
Because she was gonna get money from me.
Okay, and I paid her,
I guess.
I paid her the money.
Right.
All right. Did I commit an offense? Back to my question.
Yes.
Okay, what offense did I commit?
But you, I mean, I guess it was your idea, but I wouldn't know what to,
Okay,
I don't know what the charge would be.
all right, okay. All right, juror number 6, have I committed an offense?
Yes.
Okay, you seem hesitant.
Yeah, because I don't know what it's called either.
is what I'm
Okay,
committed to.
yes.
Capital
I didn't
murder,
know.
because it's murder plus remuneration, right? Murder for hire, or the promise, right? Either one of those things. So, let's say juror number 7, that I, reach out to Marissa again, I say, look, I need Tommy handled, I need you to take care of this. And I'm gonna give you Louis Vuitton, I'm gonna give you $5,000, yeah, that's all I'm gonna give her. She goes up to Tommy, she kills him, have I committed an offense?
Yes.
Alright, but this time, I don't pay her, I don't give her the money. Have I still committed an offense?
Yes.
Why have I committed an offense?
Because you still prompted, the capital murder with the promise
Okay,
thing.
has she committed an offense? She didn't even get the money,
Yes.
okay? What offense has she committed?
Murder.
Okay, just murder?
I guess capital murder as well.
Okay, you said you guessed. Tell me the hesitation.
Just that she was the one that carried the actual act of the murder,
Okay, and she did it for what?
the promise of money.
Got it, okay. Juror number 8, do you agree with that? Both of them would be capital murder. Juror number 9, what are your thoughts?
I agree.
Okay. Juror number 10,
Yes, I agree.
you agree both instances would be capital murder. Either I pay her in the first instance, and then the second one, I told her I was gonna pay, but I was a cheapskate, and then I didn't give her the money. Yes?
Yes.
Okay. Juror number 11?
Yes.
All right. Juror number 12, how do you feel about it? You think they're both? Okay. Juror number 14, what about you? Capital murder, you're so soft-spoken. Juror number 15, what are your thoughts?
Yeah.
Okay. Anybody that says, look, Crystal, I get it, but we are kind of at the point where, I mean, you didn't give her the money, she didn't actually get the money. I don't know that I would be okay with that being capital murder. Anyone that says, yeah, I see a hand. Juror number 46?
Yes, on the second one, it's like, it's just hearsay, they just, I don't know, the second one, I'm
On the promise.
on the promise.
Okay.
Promise.
And so you understand that even if the state proves to you beyond a reasonable doubt that there was a promise to get paid, right? But the person didn't pay, you wouldn't be able to find that person guilty. Is that what I'm understanding? All right, thank you. Juror number 47, how do you feel about that?
You mean about what she just said?
What she's saying, yes.
No, I could, the capital murder for me,
All right.
stand for both, the promise if they proved it.
Okay, and juror number 50, how do you feel?
I would say both of them, so capital murder.
Okay, anyone else that is like juror number 46, like, I don't know, I wouldn't want to find a person guilty of capital murder if there was just this promise to pay. Juror number 43?
Yeah, you'd have to prove the promise. I mean, you'd have to.
Well,
prove that
absolutely.
You said it, you'd have to, there's a lot that goes into that.
Absolutely, we would still have to prove that a promise existed, or some form of promise of a payment. We still have to prove that to you beyond a reasonable doubt. But what I'm saying is, there's some people that are just like, I understand what the law is. I just don't believe, basically, that the promise should be enough to find a person guilty of capital murder. I need to see actual money exchange hands, is basically what I'm asking.
I think what Ms. Biggins is saying in another way is that even though there was a promise, okay, maybe she promised Marissa some money, and based on that, Marissa went ahead and did the deed. And then Crystal decides to stick her and, say, well, I'm not gonna pay you anymore. But Marissa did the deed because of that promise. So she's asking you, well, are you going to, not be able to find,
I feel like
Marissa
capital
guilty?
murder for her, but the person that promised and didn't do it, but did do it,
that your position? That's the question, really.
Right on the person that's,
Me.
because you're saying two people.
Correct.
So the person that did it, I mean, yeah, that's, if you can prove to me that they did it, that's capital murder.
But they've also proven to you that there was a promise for the payment. That Crystal promised, made that promise. You know, found beyond a reasonable
If
doubt.
it's
or-
proof and it's verbatim that, yes, this was said and there is proof, then possibly yes. I mean, I would say yes, but
Thank you, I think you already have
Thank you.
43.
All right, juror 29, you were kind of raising your hand.
Yeah,
Tell me how you feel.
I think the promise part of that would have to, they have to have a very high burden to believe that. I think the burden part is like, I think a little bit more easy to understand, but with nothing being changed, it would be hard for me to assume that was true.
So you would require actual payment. Is that a yes?
Yes.
All right, anyone else that feels that way? And it's completely fine if you do. I'm just trying to, know exactly who it is, and if you disagree with the law, that's completely fine. Juror number, you are
37.
37, you feel that same way?
Yeah, I mean, either way, I feel like there's, whether there's a promise or not, maybe they are both guilty, but there shouldn't be the same consequences,
Okay,
if that makes sense.
okay.
I mean, 'cause it, like she said, there has to be a lot go into being able to prove a promise and just a handshake, then unless you're right then and there.
Oh. All right, anyone else that I missed?
I do have a
Juror
question.
number
9.
9, thank you.
My question is this hypothetical situation, to use the term guilty by association, right? Yes, you did not pull the trigger,
Right.
but you influenced, you caused the thought, hey, I could do this to get this.
Right.
Like, would that be something that could be used to say, yeah, you should be guilty of that same offense because you caused this person
Right.
to do this act?
Right, and so what you're talking about guilty by association, it's not necessarily just because I know you and I'm a bad person, you know, that you would be guilty of something. Does that make sense?
It does.
It is, there has to be some type of overt acts or aiding, and even if not an overt act, but aiding, soliciting, encouraging, all of those things. The statement that I've made and the promise that I've made for her to go do it, right, is what kind of set this in motion. Does that make sense? And so it's more than just guilty by association, because when I think guilty by association, I think of people like some bad folks hanging with, and I just kind of happen to be there, but I'm not doing anything. Does that make sense? Everybody kind of understand that distinction? All right, and we're gonna talk a little bit about the law of parties here shortly, but just in general, I wanna make sure that everyone's clear on the law. The state can prove actual payment or just the promise of a payment. And what that means with the promise of a payment, actual payment doesn't even have to be exchanged. Does that make sense? And so I understand, that some of you all are like, look, I wanna see the money be exchanged, and that's fine. I just wanna know who you are so that we know. Does that make sense? All right, anybody else that's agreeing with juror number 46?
My question is, does it have to be money, or what if it's about safety instead, like?
So sometimes there could be a benefit, reward, something like that, but we have alleged US currency in our indictment, okay? Anyone else? Would I miss? Yes.
Clarification. So
And-
the question about capital murder is only with respect to the person who pulled the trigger right now.
No, I'm asking about me.
Oh, for having cited,
Yes,
I see,
I'm asking about me. You are juror number, I'm sorry,
26.
26. Juror number 26 was asking the question as to whether or not, I was asking who's guilty, like me or Marissa, but I'm asking about me. And I never actually pulled the trigger, right? Everybody clear on that? Anybody that says no, Crystal, you're not guilty. Thank you all. You are. Anybody over here, y'all understand? Y'all are not gonna require the state to show actual payment, right? Yes. You seem hesitant.
I'm curious about, is capital murder, when you don't actually make the payment, is that more coercion relationship or a different statute than capital murder?
No, so it's the promise of the payment, it's still capital murder, because it's murder plus, that promise. Does that answer your question?
Yeah, it does.
Okay, how do you feel about it?
That's what the law is, I guess.
Oh, I like that you say that that's what the law is, but here's the time, if you don't like the law or you don't agree with it, this is the time to let us know.
I think the question is not whether they like the law, but whether they can follow it regardless of their feelings.
Right.
That's the question.
Yeah, that's what the law is, yeah.
Okay, because once you get in this box, at this point, you can say that you disagree with the law, and no, I wouldn't follow it if I had to. But once you are sitting here as a jury, as a juror, the judge is going to instruct you, as I stated before, that you will be required to follow the law if the state proves to you beyond a reasonable doubt. Does that make sense? And so my question again is, if we prove to you beyond a reasonable doubt, that I did this act by, recruiting Marissa and I stiffed her on the payment, would you be able to find me guilty?
Yeah.
Okay.
I mean, that's the parameters.
Okay, all right, awesome, thank you. So, one other thing, I'm gonna go one step further. Juror number 21, you been understanding everything? Everything good? Number 21, are you not 21? Yes.
Oh, yeah, I speak English.
No, I knew you spoke
Oh,
English,
okay.
I'm just still asking
Oh,
if
I-
you understand everything. This is a lot. Okay, I know, sometimes the law can be a little confusing, so I didn't mean about
Oh, no, you're
English or
fine.
not.
Yeah, you're fine.
Okay, say in my hypothetical, you remember, me and Tommy still don't really like each other, I don't like him, right? And I'm gonna take him out, I'm gonna ask Marissa to take him out, and she's going to actually recruit Rick, raise your hand. And Rick is actually the person who ends up killing Tommy. Now, Marissa's getting a bag and $5,000, right? And then Marissa gives him some money to get it done. Am I guilty of capital murder still?
Yes,
Okay, tell me why.
because it was all created within you, and then you then directed and recruited other individuals, and they influenced other individuals to commit the act.
Okay, juror number 23, do you agree with that?
I do.
All right, juror number 23, is Marissa guilty of capital murder?
Yes,
Okay, tell me why.
because she accepted the money and then she recruited somebody else to do it.
All right, juror number 26, is Rick guilty of capital murder?
Yes,
Yes? Okay, tell me why.
because he committed the murder before he emerged.
Okay,
Or
all right.
officer.
Okay, anybody that says 1, 2, or 3 are not guilty of capital murder? No? Everybody good? All right, let's move on. Intent. A person acts intentionally or with intent with respect to the nature of his conduct or to a result of his conduct when it is his conscious objective or desire to engage in conduct or cause the result. In other words, meant to do it on purpose. Make sense? I mean, it's pretty straightforward. One of the things that I want to tell you about when we're looking at whether or not a person intentionally or knowingly committed a murder is you get to look at what happened before, during, and after an offense. So a lot of times when we're talking about these cases, it's not kind of piecemeal. One thing by itself may exist, but it means nothing until everything is together. Does everyone understand that? So when we're talking about proving these elements to you all beyond a reasonable doubt, each of these elements, you understand that you can take into context everything that is presented, right? And beyond a reasonable doubt, that is true to you, right? It's based off of your feelings. It's not defined legally. There is no definition. But what I can tell you is what it's not. It is not 100%, right? Because if you are 100% certain and that something happened, juror number 35, Are you a witness or not to that offense? If you saw it and believed it 100%.
If you saw the crime happen,
Mhm.
then you're a witness.
You're a witness. And then you would be able to believe that at 100%, right?
Right.
So you wouldn't be here being a juror, right? In this particular case.
Yeah.
And so a lot of times, sometimes people feel that they need 100% proof, right? But realistically, that's sometimes a little unrealistic because in order for us to be 100% certain, we would have needed to be there, right? Yes? Yes? So, beyond a reasonable doubt is not beyond a shadow of a doubt. Has anybody heard of that term, beyond a shadow of a doubt? My Perry Mason fans, beyond a shadow of a doubt. That is not what it is. It is beyond a reasonable doubt. Doubt based off of reason. But what I can tell you is it's only to those elements that we have alleged. Because sometimes there are situations where we may not have all of the answers to everything, right? That may not necessarily matter. And one of the things that we want to make sure is that we have to prove those essential elements, those ingredients,
Carmen, we approach.
beyond a reasonable doubt.
Yes, ma'am.
I don't know, you know what I mean?
Yeah. Ladies and gentlemen, we're going to take a 10-minute break. So let's be back here at 12:20. Use the restroom if you need to, okay? good enough?
That's good, that's right there.
Okay, that's good. Thank you.
Thank you.
meet y'all for lunch, okay? Ms. Bennett, are you ready to proceed?
Thank you, Your Honor. Yes, I am.
Go ahead.
Thank you. All right, so basically where we left off, we were talking about beyond a reasonable doubt, which is the standard that we have to prove each and every element that we have alleged to you all in order to find Mr. White, in order for you all to find Mr. White guilty of capital murder, right? And so when we're talking about beyond a reasonable doubt, where we left off is talking about that what it's not. It's not 100% proof. It's not beyond all doubt or a shadow of a doubt. Basically, what I like to tell people is you use your common sense and your logic and what's true to you, right? Because when we're talking about this type of offense, we want to make sure that, yes, you do hold the state to its burden, but it's not an unreasonable or an unmeetable burden. Does that make sense to everyone? All right. And if the state proves the case to you beyond a reasonable doubt, you must convict, right? Because we've stated when you come over here and you're jurors and you're sitting in these luxury box seats, right? You all will be instructed by the court that if you believe that the state has proven this case to you beyond a reasonable doubt, you will have to find the defendant guilty. Now, if we don't prove the case to you beyond a reasonable doubt, juror number 29, what's your verdict?
Not guilty.
All right, juror number 26, you agree with that? Is that yes?
Not true.
Okay, all right. So, like I told you at the beginning, this is a burden that we fully accept. We believe that we have the strength and the type of evidence to support this. And therefore, when we're asking you to do this, we just want to make sure that no one here is going to hold the state to a higher burden than beyond a reasonable doubt. And juror number 17, why do you think that the standard for a criminal conviction is so high? Beyond a reasonable doubt, why? Why do you think that is? What's at stake for the defendant? Anybody want to help her out? I'm sorry? The crime? Okay, juror number 32, you were raising your hand. Freedom, right? Everybody agree with that? That's the reason why it is the highest burden that that the state has, is because we are talking about someone's freedom, right? So, what my question to you all is there anyone here that says, no state, for this type of crime, for capital murder, I'm going to require you to prove this 100%. Anyone that says, look, fundamentally, I just need to know 100%, gonna require the state. And you are juror number 37, I believe we have you. Anyone? Any other hands? Anybody in my jury box? Everybody's okay? Understand beyond a reasonable doubt? Gonna hold the state to our burden, not an unmeetable or an unreachable burden. All right. Juror number 31, how are you today?
Good.
All right. Can you tell me what these puzzle pieces make a picture of? What's the picture? It's not a trick question.
I don't know.
Right, that's the answer. Correct answer. You shouldn't know, because I have no idea either, okay? What is it now, juror number 31?
It's a handgun.
It's a handgun. Juror number 32, you agree with that?
It's an image of a handgun.
It's an image of a handgun. Either way, the image is a handgun. The photo, the picture, it's a handgun. All of the pieces are not there. Juror number 34, are you able to tell that that's a handgun?
Yes,
How are you able to tell that?
because it's almost fully there.
It's almost fully there, but there are some pieces missing.
Yeah, but it's close.
It's close enough, okay. Here's the thing. One of the reasons why I like to use this image, when we're talking about beyond a reasonable doubt and we're talking about the elements that we have to prove beyond a reasonable doubt, this is an example of that, right? Not necessarily all pieces of the puzzle have to be there. Does that make sense? It's, when we look back at this, these are individual pieces that when you put them together, So when you have pieces of evidence and they can be combined in order for you to make that inference, is that correct, juror number 35?
Yeah.
Does that make sense? Yes?
If we filled in the rest, it wouldn't change.
It wouldn't change, right? Did everyone hear that? If we filled in the rest, it wouldn't change. Does that make sense? Juror number 36, does that make sense to you? All right. All right, so I'll start off with you, juror number 36. How do we prove a murder for hire case? What would you like to see?
Evidence.
Okay, that's a good answer.
I mean,
What type of evidence?
I would probably need some transcript, recording, discussion about the actual murder and like that I'm gonna pay you for it, rather than just hearsay, like I heard somebody say, somebody is gonna do this.
Okay.
And then, I mean, evidence.
All right, all
I
right.
don't know, I'm gonna
Yeah,
say
no,
all
that's a
of
good
it.
answer. Juror number 39. Is that Ms. Garcia? Have you been understanding everything?
Pretty much.
All right, awesome, good. What type of evidence would you like to see in this type of case?
Witness?
Witnesses. You knew what was coming next, right? Okay.
Oh, no.
You didn't even see my slide. All right. Direct evidence. When we're talking about, typically there's two types of evidence, direct evidence and circumstantial evidence. How many people have heard of circumstantial evidence? Quite a few people, okay. Someone that raised their hand for circumstantial evidence. You're like, I don't want to be called on. Jury number 26, right?
Yes.
Okay, what's circumstantial evidence?
Yes, it would be evidence that is not 100% by itself a direct indication of something, but possibly the context and other elements imply something very strong.
Can did everyone hear his answer? Something by itself that is not 100%, but in the context of other things that are taken in, basically in combination, that you're able to make, what was the last word that you used?
A possible implication of something.
An implication or an inference, right? Is that fair? Okay. So when we're talking about circumstantial and direct evidence is eyewitness testimony, right? That would be a person that comes in and says, this is what I saw, right? The state is allowed to use either type of evidence, circumstantial evidence. Honestly, there's tons of things that are circumstantial evidence. Video evidence, actions after the crime, statements made, flight from the scene, photos, DNA. I mean, it could be anything. Sometimes people hear circumstantial evidence, and have any of the people who heard about circumstantial evidence ever heard it be referred to as weak evidence? No? No? Okay, good, good. Oh, juror number 32? You've heard of that? Okay, and one of the things I want to tell you is the state can bring you direct evidence or circumstantial evidence. We are not required to bring you one or the other. It can be a combination of both. Does that make sense to everyone? All right. And so when we're talking about how we prove our case, juror number 32, I would like to know, what else would you like to see?
Text messages?
Okay, text messages, because most people have phones, all right?
Email?
Emails, all right?
If they're using email to do this crime,
Okay.
they're probably not very good at it.
Okay, okay, all right. Who chooses what evidence is left behind at a scene? I know it sounds like a really odd question. Juror number 35, you look like you were about to answer.
Whoever did the crime.
Right, yeah, I know, it seems like a weird question, but who controls kind of what evidence is left behind? The defendant, right? So sometimes we have cases in which there may be a weapon. Some people are like, well, if you've alleged a deadly weapon, we want to see a weapon, right? Right? Right?
Yeah.
Okay, yes. So sometimes, yes, you do want to see those things, and you want to have those things. And I will tell you, the state of Texas will bring you all of the evidence that we have within our possession. We will. And in order for us, because we want you all to be confident in whatever decision that you make, right? But there are some times in which, what happens if a person commits a crime and then they get rid of a weapon? Does that change the fact that in my hypothetical, if I kill Tommy and I get rid of the weapon, Tommy is still what? Right? And as long as the state shows that that I killed him, right, with a weapon, that weapon being a firearm, right, not like a knife, right? I have to still prove that manner and means. Does it matter whether or not I have the weapon or not? No? I know we would like it. We would too, right? But the question is whether or not you're going to require the state, even if we prove to you the case beyond a reasonable doubt, whether or not you would require a certain type of evidence. Does everyone understand my question? So if we prove this case to you beyond a reasonable doubt and you believe it, and you're like, man, the state, I want them to bring that weapon, you know, or whatever type of evidence is in your head. The question is whether or not you would be able to find the defendant guilty without that particular piece that you would want to see or require the state to see. Does that make sense? Yes? All right. Anyone that's like, you know what? No, I'm going to require the state to bring me a certain type of evidence, even if I believe the evidence that supports a conviction and it's been proved to us beyond a reasonable doubt.
I think you might be confusing the jurors.
Okay, I'll rephrase. Is there anyone that is going to require the state to provide a certain type of evidence? No? I'm seeing no hands. All right, awesome. Okay, one of the biggest things that, and the reason why I asked that question is sometimes who watches any of these shows? Yeah, they do some pretty cool stuff there, right? They're like taking out people's retinas and then rewinding in time and seeing all kind of stuff. I will tell you, we are the government. We do not have that kind of resource. That is fake, that is TV, all of those things. And so that is the reason why I asked that question, whether or not sometimes people are like, man, I have to see X. Does that make sense? All right. This is one of my favorite quotes by Theodore Roosevelt that says, no man is above the law and no man is below it. Nor do we ask any man's permission when we ask him to obey it. Juror number 41. How are you today? What does that mean to you? No man is above the law or below the law. Well, let me ask you a different question. Who can be victims of crime? Anybody. Can a sex worker be assaulted?
Yes.
Can a thief be a victim of theft?
Yes.
Can a person who is in prison be murdered? Yes? I see everybody kind of shaking their heads. The point of this, no man is above the law or no man is below it, is that we protect people regardless of if they have different walks of life from us. Does everyone agree with that? Yes. Right? Because the society that we live in requires that, right? For us to make sure that we are protecting everyone, right? So sometimes people make different decisions. Is that fair? All right? And we may not necessarily agree with everything that they've done, right? And so when we're talking about whether or not does a person who chooses a different lifestyle, do they deserve to be protected under the law? Yes? All right. And so when we look at that quote, no man is above the law and no man is below it, that's kind of what that means, is that everyone deserves to be protected under the law regardless of what kind of decisions they make. Is that fair? Yes? Okay. Let's talk about witness credibility. All right. A lot of times, isn't this cute? You see this witness says, I did not eat any cake. Is that witness credible? Do you believe this kiddo?
No,
Why not?
because he has a parent all over him.
Okay. Now, juror number 47, did you see this kiddo eat the cake?
No, I didn't see it.
Okay. All right, so there's no direct evidence, but do you believe that this kid ate the cake? Or at least tried to?
Yeah, I think so. It's pretty obvious,
Okay. Why is it so obvious?
because he's got the cake all over his face.
All right, juror number 51, do you agree with that?
Well, how do we know that's cake?
Okay, all right, that's fair. All right, it could be anything. It looks like cake to me, but maybe iced it in a little cake. Juror number 54,
Yes.
what about you?
I mean, it looks like he has icing on his face, we're gonna presume it's icing, so he has
Right.
to eat the cake.
Okay.
Try to.
All right, so when we're talking about witness credibility, as jurors, you would be the exclusive judges of the facts, right? That means that you can believe all, some, or none of what a witness says, right? Are you all, juror number 54,
Yes.
are you comfortable with assessing witness credibility?
I think as comfortable as it can be, yeah.
Right, looking at the facts, does it match up, does it make sense, right? You feel comfortable doing that?
Yeah.
Juror number 55, how about you? Okay, all right. So as I talked about witness credibility, you are the exclusive judges of the witness credibility. What the law says is you cannot automatically believe or disbelieve someone before you hear what they have to say. And y'all remember earlier when Judge was doing her portion of the voir dire, she was talking about police officers. One of the things is that we definitely hold certain professions in high regards, right? But we all are very much well aware that there have been people in certain positions that have disappointed us. Is that fair? When we hear about certain things that they've done, whether that's police or priest or whoever, right? We've heard and feel certain types of way. What we're talking about is when a witness comes in, you just have to wait to hear what they have to say before you can decide and make a decision. Because we know that some people lie, some people tell the truth, right? Yes? Okay. Juror number 45. How are you? You doing okay? I know, it's still okay? All right. Juror number 42.
Yes.
How's it going?
Good.
You been understanding everything?
Yes, ma'am.
All right. So when we are talking about witness credibility, you must be open-minded and persuadable. Now, as soon as they hit the witness stand and they say the first thing, you can say, I don't believe nothing that they said. Or you can say, oh man, I really believe them to tell that they're telling the truth, right? Are you comfortable in waiting
In waiting.
to hear what the witness has to say before you make a determination? Juror number 41?
Yep.
You comfortable?
Yep.
Juror number 39? Yeah, okay. All right. Okay, juror number 60. Are you comfortable in doing that? Is that yes? Okay. All right. Anybody know who this person is? I heard somebody whisper it. John Gotti. Juror number, are you 39? 38. Are you aware of John Gotti and who he is? No?
He was part of one of the crime families in New York.
Yeah, the Gambino crime family. Juror number 6, I see you shaking your head. They call him the Teflon Don, right? Basically, John Gotti was famous or infamous for beating cases, right? He was famous for beating cases, like notoriously. They couldn't get him any charges to basically stick. Does anyone who knows John Gotti or the story of John Gotti know how he ended up going to prison for life? Juror number 38.
It was the RICO Act, correct?
He was indicted for a ton of stuff.
Yeah, but that's how.
But yes, yeah, I believe that they did seek a RICO, yes.
Because I thought when they formed the RICO Act was when they actually were able to get
Right.
multiple.
But what was one of the key things that the state used?
Tax evasion.
tax evasion, yes, but a piece of evidence that the state used. Somebody said it, say it again. Snitches. Snitches, that's what he said. I'm just repeating the word that he used. He said snitches, rats. That's what I've heard people say, right? Accomplice. Y'all know who that person is? Sammy the Bull, yes. Sammy the Bull. Who was Sammy the Bull? You are juror number 68? His right-hand man. That was his right-hand man. He was what? Doing the dirt with him, right? And what happened with Sammy the Bull? What did he do?
He got charged with all the crimes.
He did? But what did he do?
He snitched and went to witness protection.
Yeah. Ultimately, yeah, he did. He snitched and he ultimately ended up going into witness protection long time after that. But basically, he ended up turning state's witness. Juror number 68, what does that mean?
Well, say it again.
Turn state's witness, what does that mean?
So I guess the people that were on there, he flipped on them.
He flipped against John Gotti, right?
Right, all those people.
Okay, how do y'all feel about that? The word snitches, rats. Juror number 58. Because you're the one who started us using these words.
I don't like it.
Okay, you don't like them. All right. Juror number 59. What about you? Not a big fan. Okay. Juror number 60. You don't like them. Why not? Tell me why. No loyalty. Juror number 63. No loyalty, right? Okay. Here's a question. Do we sometimes think that those people, the right-hand man, regardless of whether or not they're loyal, if Sammy the Bull was right there doing everything with him, what does he have that's useful? Credibility. Information, right? And juror number 32, you're shaking your head. How do you feel? What do you think?
I think that people that do that are trying to keep themselves out of prison as well.
Absolutely. Yeah. Anybody else agree with that? That they very well may be telling in order to keep themselves out of trouble. Is that fair? Trying to protect themselves and their family. And I'm sorry, juror number 9, you said? Plea bargain. All right. Let me ask this. Does it mean that Sammy the Bull's information was incorrect or untrue? No? Juror number 8, tell me why.
Because if I'm hearing right, if he was doing the acts with him, then that means now he's an eyewitness, which means he has direct evidence.
He's got front row seat. He's a witness, right? Front row seat. Here's the thing. I think by nature, there's some people who are just like, you know what, we don't trust this person, we don't like this person. Loyalty, right? However, even if Sammy the Bull came in here, remember we just talked about waiting and seeing and listening to what they have to say, right? Even if you have strong feelings one way or the other, because you would still need to judge Sammy the Bull's credibility just like you would judge any other witnesses, right? However, this is what the law says. The law talks about if there's any accomplice witness testimony, a conviction cannot be had upon the testimony of an accomplice unless it's corroborated by other evidence tending to connect the defendant with the offense. Does that make sense? So basically, just because somebody, Sammy the Bull in our hypothetical, wants to come in and tell on John Gotti, he can come in and tell, but there needs to be additional evidence. And that evidence can be any type of evidence. It doesn't have to be a specific type. Does that make sense? I haven't really talked to you guys. Juror number 66, why does that make sense?
Can you repeat the question? Sorry.
It's okay. So I was asking, why does it make sense for the state to have to, if we bring in Sammy the Bull of additional information. Why does that make sense?
Because he could probably be lying.
Right. In order for you to be able to assess the credibility of the witness, right? Is there something that corroborates what this person is talking about? Does that make sense to everyone?
Yeah, because he could be trying to save himself.
He could be, right? But you as a juror, you would have to listen to what they have to say and determine whether or not that information is credible or not credible, if it matches up with something else. Does that make sense? Does everyone feel comfortable in the event that that was a situation in doing that? Yes? Is that a yes? I know y'all are getting tired. Okay. All right. And so you can look at kind of the relationship of the parties. You can look at things that happened before, during, and after, the same way when we talked about intent. Does that make sense? All right. Juror number 23, you with me?
I'm with you.
All right. All right. Has anyone seen any of these movies? Yes? All right. My favorite to use is Ocean's 11. Yeah? Juror number 10?
Yes.
You remember this movie?
Yes.
Okay. This version was actually, I think in like 2001. Man, that's crazy. But it was a remake, right?
Yes.
Of an original.
Yes.
Now, with this particular movie, with Ocean's 11, can you just kind of generally tell the jury what happened in this movie? What were they trying to do?
A heist in Vegas.
A heist in Vegas, all right, and how many people were involved?
11.
Okay, and with those 11 people, did all of the people have the same skill set?
No.
What was the reason for having so many different people?
The skill sets.
Everybody had a different set of skills, is that right?
Yes.
Why was that important for them?
In order to pull the job off.
Okay, because they want to be successful, right?
Right.
So they had different people that had different roles. Do you remember George Clooney's role?
Not really.
Okay, anybody remember? Juror number, I'm sorry, 47. 47, yes.
He was kind of like the one that put it all together.
Right, he was like the mastermind, is that right? What about Brad Pitt?
He was with him also.
He was like his right-hand man, right?
Mhm.
Okay, what about this guy? Anybody remember him?
He funded it.
Who said that? Juror number 73, he funded it, right? Do you remember in the movie, was he ever at the casino?
No, but he was at the warehouses and stuff. And
Okay.
at his palace.
All right, and he was at his palace, because remember at the beginning of the movie, they actually go to his house to talk to him about it, right? And he agrees. He's like, okay. He's like, whose casino is it?
And then he was in.
And then he was in, right? He was like, wait a minute, whose casino is this? Now, here's the thing, here's a question. When we're talking about the law of parties and all of these people or 11 people working together, the question is, were all of these people, even for those who haven't seen this movie, if they're all working together, different skill sets coming together in order to pull off this robbery of a casino, would they all be guilty of robbery? Yes? Juror number 73, if they had gotten caught, would they have all been guilty?
I mean, I think it depends on the jurisdiction, but yeah.
Right. Okay. All right. Everybody understand that? Even though this last guy, he didn't actually go into the casino at all. Kind of like in my hypothetical in which it's me employing Marissa employing Rick. I never pulled the trigger, right? So what the law says is a person is criminally responsible for the conduct of another if acting with the intent to promote or assist the commission of the crime he solicits, encourages, directs, aids, or attempts to aid the other person to commit the offense. Mere presence alone is not sufficient. Does the law of parties make sense? How a person could end up being responsible, kind of like in my hypothetical. I'm still responsible for killing Tommy even though I didn't actually pull the trigger.
Right.
I'm still responsible if I made the promise to pay, right? Or either pay for Tommy's death. Does that make sense to everyone? Does anyone say, you know what, no, that's not making sense, Crystal? All right. Okay. We've talked about punishment. If the jury finds the defendant guilty of capital murder, the judge will be required by law to set the punishment at life in prison without the possibility of parole. And you remember, I went down by everyone and asked, whether or not if the state proved this case to you beyond a reasonable doubt, you would be able to find the defendant guilty of capital murder, and convict him, understanding that the punishment would be life without the possibility of parole. Since I asked that at the beginning, has there been anyone that said, yes, I would be able to do it, as we've been sitting here, changed their minds and said, no, I wouldn't be able to do that? No? Awesome, good. All right. The judge briefly talked about punishment on a lesser included offense. She told you that murder is a lesser included offense of capital murder. What I do want to tell you is, during this process, we actually have to talk to you about it, even though we plan on going forward, this is a capital murder, but in the event, depending on what evidence may come up, sometimes, even if there's just a scintilla, a little bit of evidence that references that murder should be included in the charge, you all could have that as an option, right, as the juror to look at it. However, the way it works and the way the law would be explained is you would look at the first charge, and if you all believe beyond a reasonable doubt that we've proved capital murder, then he's guilty of capital murder. If you wouldn't agree that we haven't proved capital murder, then you could potentially consider murder as a lesser included. Does that make sense to everyone? All right. Murder has a different punishment range, and even though we don't know what's going to come out at trial, we have to qualify the jurors, meaning on the range of punishment, to make sure that you all can be open to the possibility on the minimum end as well as on the maximum end of murder. So imagine right now, you all know nothing about this case, correct? I mean, a little bit, but we haven't proven anything to you or presented any actual facts to you about this case, right? At this point, all we're asking when we're talking about punishment on a lesser included offense is whether or not you can keep an open mind to the lesser of 5 years all the way up to 99 years or life in prison in the event that this becomes relevant, right? Does that make sense to everyone? Is there anyone that's closed off to either the minimum or the maximum at this point, understanding that you know nothing? It's just kind of like with witnesses taking the stand, right? You don't know what they're going to say, whether or not you should believe them or not, or any of those things, right? So it's the same thing with the range of punishment as to whether or not you can just keep an open mind. Is there anyone that says, no, I can't keep an open mind to either the minimum or the maximum? First row. Second row. Third row. My short fourth row back there. Last row. Anybody in my jury box? Okay. I'm going to go through the defendant's rights because, as I told you when we started, one of the biggest things is we want to make sure that we are protecting the defendant's rights. Every person, citizen accused, has an absolute right to a jury trial. It doesn't matter whether or not the crime was committed on the 50-yard line of the AT&T Stadium, right? They still have an absolute right to a jury trial. The second thing is they have right to discovery. What that means is everything that is in the state's possession, we have to turn that over to the defense so that they know exactly what the allegations are and all of the evidence that we have. Does that make sense to everyone? The reason why that is done is specifically we want to make sure that they are put on notice, that there's no element of surprise or anything like that. But we also are doing the proving and accusing, right? So we want to make sure that they have everything.
Ms. Biggins, you have 15 more minutes.
Thank you. We do not have reciprocal discovery, meaning that the defense doesn't have to give us anything. In fact, the defense doesn't have to do anything in a case. I know that they will, but they don't have to. And what I mean by that is, kind of brings me to this presumption of innocence. Right now, Mr. White is presumed innocent, right? And so, juror number 10, if I ask you, what's your verdict? right now? It's what?
Innocent.
It's innocent, not guilty, right? And that's because I haven't proved a thing to you all. Does that make sense to everyone?
Yeah.
Right? And so he is cloaked under the presumption of innocence. Also, that kind of goes hand in hand with his Fifth Amendment right to not incriminate himself. How many people know about the Fifth? Almost everybody, right? Everybody should know about it, right? He has an absolute right to testify. He has an absolute right not to testify. It is completely his decision to make, right? And so if he chooses, the problem is you don't, or the issue is you don't know why if he chooses not to testify, why, right? What is the number one fear that people have about standing in spaces doing what I'm doing? Stage fright, public speaking, right? Tons of people are scared to get up and talk in front of people. However, we don't know that. We don't know what the case may be. The question that the judge asks you is, you understand that you cannot hold it against the defendant if he chooses not to testify. Does that make sense, right? Because what if the state hasn't proven their case? Why would he need to get up there? That makes sense? So a lot of times, look, I have little kids, and sometimes, something gets broke in the house. I'm asking, who did it? And everybody just stay inside. There is no Fifth Amendment right in my house, let me tell you. They are going to need to tell me what happened. And a lot of times we want to, by nature, it's our human nature, we want to hear both sides. And just understand that that may not be the case. A lot of times people are like, if it were me, I would get up there, right? But understand that is not what has to happen. We have our constitutional rights for a reason, and if he chooses to exercise that, what I need to know is that you all will not hold that against him. On the front row, everybody agree? Second row, I see heads nodding. Third row, short fourth row, back row, jury box. Okay. There's also, we did get a brief chance to look at you all's questionnaires, and let's see, give me 1 second. Juror number 14, I believe at some point there was a mention that you couldn't, juror number 14, I'm sorry, I was trying to make sure, that you couldn't sit in judgment of another. Do you remember that question on the questionnaire? Okay, no issues? You're fine sitting in judgment if you need to in this case, is that correct? All right. Juror number 15, what about you?
Same thing.
Same thing that you put on your questionnaire, or same thing now as juror number 14? Okay, so you're okay with sitting in judgment. All right, thank you. Juror number 29? Yes?
No.
Okay, you cannot sit in judgment. Correct, okay. Juror number 37, I'm sorry, I'm kind of lost. Where? 37, I think we got you, okay. And then juror number 59. All right, yes? You're okay?
Yeah.
You can sit in judgment of another? You seem kind of hesitant.
Yes.
Okay, all right, okay. The last thing I want to talk about is, as you all know, that, sorry, I think juror number 11, did you have an issue with sitting in judgment? I think you put that on your questionnaire. Okay, that's okay. You're okay?
Yeah.
Okay, thank you. As you all know that I'm sure that some people have kind of heard about this case in the media, in the news. Has anyone heard about it just briefly? No? A couple of hands. All right. Here's the question. It's not that you've heard about it, or whether or not even you kind of have something in the back of your mind. You may have formed an opinion about it. It's whether or not you can be fair and listen to the facts and circumstances and hold the state to our burden to prove this case to you beyond a reasonable doubt. So if you could raise your hands of the people who actually, have heard about this case. And raise your number, that'll help. Sorry. Juror number 25, I have you. I think juror number 23. My question to you is, even though you've heard something, have you formed an opinion?
No, I have not formed an opinion.
Okay, so you could sit and listen to the facts of this case and hold the state to our burden.
Correct.
All right. Anybody else on that row? Juror number 30. I think we have you. Okay. Juror number 44. I think we have you. 43. I think we have you. Juror number 34.
Yeah, I've heard about it, but I don't have an opinion.
Okay. And so you would be able to hold the state to our burden to prove this case to you beyond a reasonable doubt.
Yes.
Okay. Anybody on the fourth row? All right. Juror number 51.
I've heard about it, but I haven't listened to all the, evidence.
You can hold the state to our burden to prove this case to you beyond a reasonable doubt. Juror number 52, I believe we have you. Juror number 54, same question. You've heard about it?
I can be impartial.
Okay, thank you. Any other on this back? Juror number 63, you've heard about it? Have you formed an opinion? Okay, can you be fair and hold the state to our burden? All right. Juror number 65, I believe we have you. Anyone I missed out here? And then in the jury box, juror number 68, yes, sir.
I've heard.
Okay, have you formed an opinion? Not really? Yes or no?
No.
You've kind of had an opinion. Here's the question. Would you be able to listen to the facts and circumstances and hold the state to prove this case to you beyond a reasonable doubt? I'm sorry? Think so?
Yes.
Okay, thank you. All right, juror number 64, yes ma'am.
I don't have an opinion.
Okay, got it, okay. Did I miss anyone? All right, the defense is going to get to talk to you all after lunch. I know we went over a lot of things and information. Thank you guys so much for your attention. I really appreciate this. This is important, like I said when I started, for the state. This is important for Mr. White. This is important for the Noble family. And so I just thank you. I look forward to working with 12 of you.
Thank you, Ms. Biggins. All right, ladies and gentlemen, we're going to take a 1-hour lunch break. You'll be going down to the first floor to our 5-star cafeteria, okay? When you come back, let me know how it went. So you're still under my instructions. Please do not talk to the press. Do not talk to each other about this case. And those of you that, that have heard something or the other, please keep it to yourselves. We want jurors who are open-minded and who will wait to hear the evidence. So when you're done with lunch, please use the restroom, then congregate in front of the courtroom and the bailiff will bring you in when we're ready for you, okay? Thank you very much. has always been my instructions, and told me about it. So I'm not going to ask who it was that did that, but that is out of order. And my instructions to you, it involves everybody in here. You guys cannot talk to each other about the case. You can't talk to anybody on this side, or the press, or anyone else. Does everybody understand? I know it's tempting, but if you do that, and it causes a mistrial, that's, consequential. So please don't do that. We've come this far. We need to get this process done, okay? So, does anybody have any questions about that? Okay, thank you. The state had finished its own portion of word hour before lunch. Is the defense ready to proceed?
Yes, Your Honor.
Okay, go ahead.
Thank you. Good, is it afternoon finally? Good afternoon, everyone. Good afternoon. Good afternoon. I know, it's after lunch. I'm gonna try. My name is Bree West, and together with Myra McIntosh, we represent Mr. Kewan White. And I'm gonna try to spend as much time as I can talking to you guys and getting your feelings about sort of everything that might be expected of you as a juror, or if you're chosen to sit on this jury, kind of get as much information as I can to make a determination about, kind of where you'll fall on the spectrum, if that makes sense. But in order for me to do that, I have to know your honest answers. And I'll be honest with you, and I'll tell you that as I was sitting back here and listening to some of your answers as Mrs. Biggins was asking you questions, it felt like a lot of people were giving the lawyer answer. A lot of people were saying, okay, I know that this is maybe what I'm supposed to say, this is how I'm supposed to answer, this is what the expectation of me may be. And I think that makes sense. I completely understand it. But at the end of the day, what you now know is that Mr. White is charged with capital murder. And if he's found guilty of that, there is no punishment phase. There is no offer of explanation about why this may have happened. There is no, oh, this person had X, Y, and Z going on, mental health. None of that comes out. Because you are making a decision about sending somebody to prison for the rest of their lives without the possibility of parole, without ever getting out of prison based on an incident in time. And that's a huge thing, right? And I know that so many people are like, yeah, no problem, right? But that's a huge thing, to not know anything else about anything else and make that decision. And so I want to make sure that kind of as you're sitting in the audience and you're listening, that you're not giving the lawyer answer. Because what the answer that I think is important to give is, if it was you or your loved one sitting in this seat, would you be the right juror? Right? Like, that's really the question. And I can tell you right now that because of what I do for a living, because I practice criminal law, it's unlikely that I would be a good juror, right? Because I have really, 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 really strong opinions about the criminal justice system, about how people are treated inside of the criminal justice system, and those things would absolutely affect me if I were chosen to sit on a jury. And that's really what the point is here, right? So as you think about, if I were to listen to these facts and this evidence, and if I were to come to the conclusion that this person is guilty, that also means that I am not knowing anything other than this moment in time, and sending somebody to prison for the rest of their lives without ever getting out. No possibility at all means no possibility at all. So I really want to have this discussion with you guys with that really firm understanding of what this actually means. A lot of you kind of indicated that you're a little bit familiar, or maybe you heard the news, or maybe you watch social media or whatever, and you're aware of some of the facts surrounding the allegation. Is that right? Did I understand that there are some people that are aware of that? Nobody's aware now? There were people that were aware before. Okay.
So I want to ask you, who is familiar with the rapper Mo3? Can you just raise your hands? Could you raise, you know what? Could you raise your cards? Is that okay? So some people, okay. Is there anyone that's familiar with the rapper Yella Beezy? Kind of the same people. Okay. I think that there are people that have already answered this, but raise your hands if knowing anything about either one of those people, Mo3 or Yella Beezy, would affect you, whatever information you have, would affect you in making a decision if you were chosen to sit on this jury. Can you raise your cards if that's the case? Okay. I'm gonna come back real quick. Is it number 64, Miss Lewis? Yes. Hi, yes ma'am. I think you raised your hand in saying that you do know the rapper Mo3, is that right?
I'm aware of who he is.
Or aware, that's a better way of saying it, thank you. And you're also aware of the rapper Yella Beezy, is that fair? Okay. And are you aware of them because of their music, or are you aware of them because of anything that you've heard or learned about the allegation involving the both of them?
The music.
The music. And let me ask you about some of the music. Are you, obviously you listen to rap, is that right?
Yes.
Okay. And in your experience in sort of being somebody that enjoys rap music, are rap artists always rapping about what it is that they live? Or are there some rap artists that rap about, things that they know are controversial or want to get likes or clicks or make money from their music or present a specific persona of what they think rappers should be like? What is your opinion about that?
What was the question?
You're right. Thank you. I might be tired too. It's been a long day for me too. And so my question is just kind of, what is your opinion about rappers? Like, what is your opinion about rappers? Let's start there.
What is my opinion?
Yes.
To answer, one of the questions you asked is like, do they rap about things they have experience with? I don't have any knowledge of what they have experience with. I can't answer that question.
Okay.
So I don't know if they're putting on a front or if they're really rapping about what they're saying.
Okay. And maybe both, right? Maybe some rappers rap about what they've been through. Could you agree with that? Maybe.
I can't speak to what they've been through.
Okay. But would you agree that rapping or entertainment is a business?
Entertainment is a business.
And that if you're in the entertainment business as a rapper, the real primary goal is to make money. Yeah, right. I'm not a trick question at all. Obviously, if I'm in the entertainment business, I want to make money doing what I love.
Sure.
Okay, what are your thoughts? Because it doesn't seem like you necessarily think that.
I don't have thoughts of speaking about something in a broad sense because things have different vantage points. There's different views that people can have. There's certain perceptions that like to be out there. So if I'm not a rapper, I can't speak on it. I don't know what rappers are doing. That's not my lane.
Okay, I understand that. How about, is it Mr. Jones, number 63? You raised your hand and said that you knew of Mo3 and you knew of Yella Beezy. Do you know about them because of their music, or do you know about them because of any of the allegations that have come up?
Through the music.
Okay.
Music, period. If you live in Dallas and they play their songs on the radio.
Okay. Okay. And have you heard anything that has affected or has influenced your opinions about any of the allegations that are out there about the two of them?
Have I heard anything?
Yes.
Rapping about?
Yes.
Oh, no, I haven't.
Okay. And so is there anything about what you know about their music that if you were chosen to sit on this jury would be a part of your thought process as you're listening to the facts and the evidence?
Is there anything about the
Is there anything about the music, whatever it is that you know about their music, is there anything about their music that if you were chosen to sit on this jury, you know, and you're listening to the facts and the evidence in a case, is what you know about their music at all going to affect your ability to listen to the facts and the evidence and make a decision in this courtroom about what you hear here? No? Okay, so you can keep an open mind, is what you're saying. Okay, thank you. Anybody else want to talk to me about rap music? No? I know, I don't want to talk about it either. Okay, so gotta give honest answers, that's super important. I think that you guys have heard that this trial is expected to last 2 weeks at like a minimum, right? Is there anybody by a show of hands, and I think we heard from someone, that either has any kind of like ADHD, medical condition, anything like that that would affect their ability to be able to like sit here and listen and absorb a 2-week trial? And I want to tell you that there are 250 witnesses that we have been told about in this trial. And I want to tell you that there are terabytes, multiple terabytes of discovery that have been presented to us in this trial. So I want to make sure that you understand that 2 weeks is not, you know, it has, I don't know how many witnesses potentially, but I know that we've been told that there are at least 250 of them, okay? So is there anybody just by a show of hands that say, you know what, I have some things going on, some medical issues or whatever, and I cannot be a part of that? Now,
All right, before that train runs away, the fact that 250 witnesses are listed does not necessarily mean that 250 witnesses will be called. Does everybody understand that? Okay. This is a high-profile case, and so, yes, it will be tense. And what Ms. West is asking you is, will you be available for at least 2 weeks? That's, you know, the amount of time that it's projected to last. And I asked you all if there were folks traveling and when they were going to travel, and we got those responses. We've had an individual that said he has ADHD and will not be able to focus. And so this is a follow-up to that question. So if you're traveling within that time, if you have a medical condition that's not going to let you focus, we've been over that question, but if you didn't answer at the time and you want to tell Ms. West about it, go ahead and raise your hand. Go ahead, Ms. West.
Thank you. Okay, is number 55, I should have worn my glasses, is it Mr. Hedgecote?
That's correct.
Oh, yay, okay.
I do have ADHD as well, but I don't know if that would be a problem, but since you're pointing it out specifically, I do sometimes, I try to listen, but I do mistakes.
Okay, I mean, and really the crux of the question is, if you were chosen to sit on this jury, where there is a large volume, right, of potential witnesses and potential evidence, you have to be able to listen and follow and understand what's going on in order to be able to render a verdict, right? And so my question is, and only you know this, is based on your personal, sort of understanding of yourself, is that something that you can do?
I think it's something I could do, but I'd be lying if I said I wouldn't struggle at all.
Okay, and I think that, I think we all would absolutely try, right, our best. And I think that what we're discussing here is trying versus doing. I always feel like Yoda when I say that, but, and so there's not a wrong answer, okay? And so I don't want you to feel like, okay, I gotta figure out what the right thing is to say. Only you know the answer to this.
Well, let me ask you this, number 55. With your condition, do you take medication?
I used to, not anymore.
Okay, so is it something where you would require breaks in between, or is it, Ms. West wants to know if you're going to be able to, concentrate for a reasonable length of time while testimony is going on, or is this something that will be, pose a problem for you and you're just not going to be able to manage?
I think breaks would be helpful.
Okay.
I could manage it.
Okay, thank you.
Thank you, sir. And then, number 23, and also the lighting is bad here. Number 23 is, can I say Miss Amanda? I was trying to pronounce your last name.
That's Shaughnessy.
Shaughnessy, yes.
I had a call at lunch. I have a kiddo that's going to have surgery on September 10th, so that date I won't be here, but if it's done
appreciate you sharing that, thank you.
What number is that again?
That's number 23.
Thank you.
And then, number 10, Mr. Johnston.
I have bad knees and sleep for a long period of time, it really hurts.
Okay. Do you think that, that sort of the pain or anything that you're gonna experience if you were to have to sit for long periods of time, do you think that that would affect your ability to listen to the facts and the evidence and render a verdict here in this case?
Not necessarily now.
Okay, you just need to stand up or
Yeah.
periodically
Around here.
move around? Okay, I appreciate that, thank you. Anybody else? Number 6, Ms. Howell.
It's not an ability to concentrate that I have a problem with, it's excessive sleepiness. I've been diagnosed with chronic fatigue, it's a little embarrassing saying that because chronic fatigue is not, people think it's a made-up thing, but I was diagnosed in my 20s.
Yeah.
If you notice this morning, I can't stop yawning and I have a problem even like, I also have to take a nap during the day, so I usually take one of my lunch hour at work.
Okay,
So,
then obviously
yes.
we interrupted that.
Yeah.
Okay, and so I will say to you,
Yeah.
you know, this is a really serious situation.
Yes, and I don't wanna appear as like, I don't get enough sleep or I'm not prepared for, you know, I can concentrate, that's not the issue, it's this excessive sleepiness.
Okay,
Yeah.
and so you're saying that you'll be sleepy?
Yes.
I mean, you know, and is that gonna affect your ability?
Yeah, cause it affects my daily life as it is, so.
Okay,
Yeah.
okay. And so what I hear you saying is based on your medical condition, and all of the things that you just described, that if you were chosen to, this is not the right jury for you.
Right.
Is that fair?
It's
Okay,
fair,
I
yeah.
appreciate that, thank you. Anybody else? Is it number 7, Mr. Arnold? Yes, sir.
I have a trip on the 9th of September.
Okay, 9/9. Anything about that trip that's gonna make it so that if you sit on this jury, that you're not gonna be able to focus and concentrate on what is happening in this courtroom and render a verdict?
No.
No, okay, thank you so much. Anybody else? Oh, is it Mr., number 13, Mr. Dang?
We have number 13 already.
Okay, and I wanna say that if I don't get to ask you a question, or if you don't get to say what you wanna share with the group, understand that it's because of time constraints. I am not being rude, I am not being unkind. I wanna hear what you have to say. Okay, number 14, did I see you, did you put your placard up? Yes, ma'am.
I just get really bad migraines.
Migraines, okay. Obviously, if you get a migraine, you know when they're coming on. What is it that you need to do if and when you get a migraine?
Usually just take a break.
Okay, take a break.
Yeah.
How often would you say you get migraines?
I can barely hear. Sorry, can you speak?
And
up a
I'm
little bit?
gonna walk over here just because it's gonna force you to have to talk louder.
A few times a week, but, you know, I just take a break or take time or something.
Okay. Is there anything about like the fact that you get migraines a couple of times a week, you need to take a break, you don't know when they're coming on? Like if you were to be chosen to sit on this jury, would that be difficult, like not knowing when you're getting a migraine, or does it affect your ability to focus or affect your ability to be able to intake large volumes of information?
In other words, can you manage to be on the panel and concentrate and manage your migraines with your medication and breaks? That's the question.
Yeah, I have a question.
Okay. I think I saw Mr. Carroll, you had your number 15, you had your placard up.
Yeah, I had 3 aortas, and so I'm on the medication, and I seem to lose focus in a long period of time.
Okay. If you are, do you think that your inability to focus on it for long periods of time will, if you were chosen to sit on this jury, affect your ability to hear what's going on, absorb the information, and make a decision?
Yeah, hold it so I can make a right decision.
Okay. And so based on your medical condition, is this the right jury for you?
I would think not.
Okay. Is it the right jury or not the right? No, we just have to know. It's not, I'm not
No.
putting, okay, I appreciate that, thank you. Who else had a placard up? Is it number 42, Mr. Stutter? Am I pronouncing?
Yeah,
paid for your treatments, can you get your money back?
I can ask.
Okay, are they medical treatments, I guess?
Yes, like physical therapy, medical treatments.
Okay, do you need to attend them?
Yes.
Okay, are you like without them, are you in pain or have a
I
problem?
do have a problem walking right now, yeah.
Okay, and so do you think that like not being able to get the medical treatment that you need is going to be something that's gonna kind of be on your mind if you were to have to be here?
Yes, I
Okay.
would think so.
And so based on your medical condition, is this not the right time for you to be on a jury?
Yes.
Okay, I appreciate that.
All right, Mr. Sutter, number 42.
Yes,
I know the time isn't convenient, but if you were to be chosen on this jury, would you be able to focus on the testimony and be objective and arrive at a decision?
Yes.
Okay, thank you.
Okay, we may come back to you, because I think you said two different things.
Okay.
Okay, is it number 41, Ms. Woodbury?
Yes.
Yes, ma'am.
I've got back issues, nerve issues, and it shoots down my leg. And when I'm sitting down like I have been this morning, it's extremely painful. And for that, I need to take gabapentin, and I cannot focus if I'm on air.
Yes, it makes you very drowsy.
So I don't think I would be able to.
Okay, so you have a medical condition that causes you to take a medication, is that right?
Correct.
And that medication causes drowsiness, is that right?
Yes.
Okay, and if you were to have to take it during the day, because you're sitting for a long time,
Correct.
would you be able to listen to the facts and the evidence in this case?
Not if I'm taking it.
Okay, and do you know when you're gonna need to take it?
Well, for instance, I take it, if I've been sitting down for a while, or even maybe 20 minutes, it starts shooting down my leg, and then I can barely put my feet, so I would have to take it often.
Okay, and so based on your medical condition, if you were to be chosen to sit on this jury, would you be able to listen to the facts and the evidence and render, okay, I appreciate that, thank you. Anybody else? Oh, 20, number 28.
I was just reiterating my trip on Thursday, and then also I have surgery on the.
Which number is that?
28.
28.
Oh, Mary McDonald, okay. I think we have her already, she's traveling on Wednesday.
Okay. Oh, I thought it was Thursday. Thursday. Okay, I have number 20, Mr. Ferguson. Yes, sir.
I'm on Suboxone. I go to a methadone clinic every day.
Okay.
And after I take the medication, it makes me very drowsy, and I have a hard time focusing for a few hours after that.
Okay. And I think that I noted, had you gone this morning? Okay, so I noted that you seemed a little bit sleepy. Is that why? Based on that, were you able to hear what was going on or focus on what's going on?
Mostly, but not entirely.
Okay. And you understand that this is a very big deal.
Yeah.
Okay. And so your ability to focus and catch everything is important. You understand that?
Yes, I understand.
Okay, so based on just the medical condition that you have going on, and your sleepiness, and the fact that we have to start in the morning, otherwise this would go on for 75 years.
Yes.
Is this the right jury for you?
No.
Okay, I appreciate that, thank you. I thought I saw one other person over here. Oh, let's see, number 32. Oh, I was gonna try, but can I just call you Mr. Lawrence? Okay, thank you, yes, sir. Sure. Okay, is there anything about that trip coming up on the 16th that would affect, if you were chosen to sit on this jury, that would affect your ability to listen to the things that were going on in the courtroom?
No.
As long as you were done?
I am leaving on the 16th.
I'm with you. I wish I could go. Okay, anything, oh, okay, yes. And I'm, you guys are still you're my fave. I want you to know, you're my fave. Is it Mr. Lefebvre?
Lefebvre.
Lefebvre. Yes, sir, number 73.
Flight on September 7th.
Yes, we've got you. Thank you so much. I appreciate you sharing that. Okay, and I think that's everybody. Is that right? Anybody, so there was a discussion that we had about the presumption of innocence. Does everybody remember when we talked about that? Oh, well, let's back up. Let's talk about what has to be proven. Okay, so we've talked about the offense is capital murder. Does everybody understand that? And that this particular type of capital murder, for in layman's terms, is murder for hire, right? more broken down. It's murder plus the promise of payment or payment, right? Everybody understands that?
Yes.
Okay, and there was a bunch of discussions about if Mrs. Biggins, didn't like Mr. Adams, and then, Ms. Hatchett got involved, and Mr. all these different people, right? And you remember that, and there was a discussion about whether or not, who would be guilty. Does everybody remember that? I'm gonna ask, Miss Villa, am I pronouncing that correctly? Okay. So you remember that example, right? You remember the example about? Yes.
For the job.
Yes, yes, you remember that. What was clear to you about that example in terms of any discussion that had happened in the planning? Like, when do you think the discussion about the planning of that occurred?
Well, before the murder.
Before the murder. And why is that?
Because Daryl wants to be mean to the man and he wants to.
But I mean, like, if it didn't happen before, what does that mean? What would that mean?
I have no idea.
Well, if I said I'm gonna hire somebody to kill my ex-husband, which if you see that on the news, it was not me. I'm making a plan.
Yeah.
But what if the only information that you know is that there was some discussion after my ex-husband was already dead?
So you did it?
I did it. Is that what you think?
Yeah.
Would there have to have been some discussion beforehand?
I'll say no.
Okay. What do you think, number 3, Mr. Godet?
Got it, yeah.
Godet.
Close. Well, if there's discussion after the fact, then clearly that shouldn't be used as evidence.
Okay, so if there was discussion
Maybe
after,
not evidence, but evidence about the specific murder.
okay. And I wanna make sure that I understand what you're saying. If there was like some sort of discussion about, after my ex-husband was killed, that discussion after the fact doesn't have anything to do with what may have happened before?
I would hope not.
Okay, okay. Would you expect to see some kind of evidence of some discussion before somebody's killed?
If they're being charged with capital murder.
Okay, and
Yeah.
tell me why that is.
Well, if I'm gonna convict someone of capital murder with, paper hire, like, that's what I would expect to see to convict them of that.
Okay, and what if the only thing that you see is some discussion after the fact?
Is it being admitted into evidence, or, like, are they saying they killed them? I guess that's what I'm confused about.
Okay, I mean, whatever it is, like, I mean, if it's something
The
that,
timeline is important, I guess.
the timeline is important.
Yeah.
Okay, and so what if, in the timeline, you don't have any information about an agreement before somebody is killed?
Yeah, it would be hard for me to convict someone of capital murder with the paper hire.
For the pay for hire?
Yes,
And
with the talking about the agreement beforehand.
right, and so if there's no agreement beforehand, what would that mean for you?
Then it would just be murder.
Okay, and then what about you, number 4, Miss Martinson? Martinson, yes ma'am. What do you think about what, number 3 had to say?
I feel like I would have to hear all the evidence.
Right. And I'm telling you, and in my scenario, the only evidence you're hearing is about some discussion that occurs after my ex-husband is dead. That's all the evidence.
Yeah, I don't know how I would feel honestly about that.
Okay, what would you be, if you didn't have evidence of some agreement where I was paying or promising to pay somebody to kill my ex-husband?
But someone said afterwards that they did.
What if somebody did say?
Yeah, I would have to see a culmination of the rest of the evidence.
That's it, that's all the evidence. What would you be required to do at that point?
Yeah, I don't know if it could be done.
Okay, but, so you understand, right, that if you were chosen to be placed on this jury, right, you would be presented whatever the evidence might be. And if, for example, that evidence is exactly what we just talked about, that's the extent of it, okay? And it sounds like you're saying, I don't know, or I'm not sure, or maybe, or could be, or possibly. What do all of those things lead to? Does anybody know?
Reasonable doubt.
And what does that mean? What would you have to do in that instance? Okay, I love that we're doing this, okay? Because what is so important, what I'm getting from you is that at the end of the day, if you think that maybe something probably did happen, right? Like, let's just live in that space for a minute. Something probably did happen, okay? Would you agree with me that something probably happened is not the same thing as proof beyond a reasonable doubt?
I do agree with that, yes.
Okay, and so you further understand, because I know we've talked about it for 16 years, that the standard in criminal law is proof beyond reasonable doubt. You understand that? And so if you are not at proof beyond a reasonable doubt, what are you required to do?
Unless, I guess, and murder is not on the,
Just,
and lesser whatever.
we're not at that, you're jumping ahead. We're just right here.
Yes, but I guess I cannot, it would not be capital.
Okay, so you would have to say not guilty. Do you understand that? And here's the thing, I don't ever want anybody on a jury like this that has to make any decision that is against their conscience. Do you understand that? In other words, if you're saying to me, I know what the standard is, okay, but I also feel like an offense like this is extremely serious. And so even if I'm not at beyond a reasonable doubt, if I think something probably happened, then I am the person, me, number 4, I am the person that is going to decide that somebody's probably guilty, and that's gonna be enough for me. What would you say to that?
I understand the consequences of it, and I understand the difference between, that you would have to say it's not capital murder.
Would you be able to vote not guilty under those circumstances?
And Judge, I'm just gonna object for clarification. Specifically, I'm just trying to understand, there's 2 different things that are going on. I believe that Ms. West started with the fact scenario of giving what I would believe is an improper commitment question, which is differing from what I think she's asking right now of whether or not, if the state failed to prove the case beyond a reasonable doubt, then yes, that is correct, that the vote would be not guilty. But I think we kind of mixed the 2, so I'm just asking for clarification.
Correct, your objection is sustained. Ms. West, you might want to explain to the jurors a little better and not juxtapose 2 different theories together. Explain it, separately to the jurors.
Okay, so at the end of the day, I'm talking about a couple of different things that I'm combining, okay? So the first thing is the state's burden of proof and the elements that they have to meet is proof beyond reasonable doubt. You understand that?
Right.
Okay. So let's for a second assume, okay, that the state has proved beyond a reasonable doubt, maybe that a murder occurred, somebody died, there was an intentional killing, the defendant did it, it happened on a specific day, but you don't hear evidence that there was a payment. Under those facts, what would your verdict have to be?
So just without the payment,
Without the payment.
or the promise of the payment?
Well, I was gonna break those into 2, but you can do both.
Okay, now, let me explain. With the payment, or with the promise of the payment, it's a capital murder.
Murder, right,
Okay?
yes, I understand that.
So if you don't find that there was payment or a promise of payment, then it wouldn't be capital murder, it would be
Just
murder.
murder.
So I think she's
But
asking
that's
you.
what she said, I jumped ahead.
No, I'm not, I'm saying that they would have to make a decision if they were given the option of capital murder
Right,
and the state fails to prove either the element of payment or the promise of payment, what would their verdict have to be?
okay, and there's no lesser included, because that was your question, correct?
I think we don't understand quite the
All right.
definition, is what we were saying. Like, I get it the 3rd time
Okay, when you say that you're not understanding,
No.
tell me what you don't understand.
Well, no, just like the basic question, what she was explaining to you.
Okay,
I understand it has to be each of the criteria in order to be capital murder.
right.
But I don't think, when you're talking about the reward, like, I don't know, correct me if I'm wrong, but,
You're saying murder is not an option on the
right,
table.
Right.
right,
A
right,
lesser charge is not an option on the table.
Right.
And you're saying, would that be considered capital murder or not?
Right.
You would have to say it's not capital murder.
Right.
The definite, as per the definition of capital murder.
And yes, and so I'm asking you that if there is an element that is not proven beyond a reasonable doubt, and your
If they
only
did not prove
option
their case.
is capital murder,
If they did not prove their case beyond a reasonable doubt, correct,
what would your verdict have to be?
not capital murder.
Not guilty.
Not guilty, I'm sorry. I'm gonna say murder, not capital murder.
Right, and here's the
but not
thing.
guilty for capital murder.
Right, and we don't, because you don't know anything, you don't know what any evidence is gonna be, you don't know whether or not, a lesser included offense is coming in, you don't know any of that. And so what I wanna make sure of is that you are comfortable that if you are presented with just the option of capital murder, maybe you think something happened, but the state failed to prove every element beyond a reasonable doubt, whatever element you think that is, can you vote not guilty?
Yes,
That's the
I
question.
can.
Okay, can you do that? Okay, is it number 7? Do you understand my question now? Okay, so if all you're given is capital murder, okay, and you don't hear any evidence of an agreement for payment or a promise of payment or payment, what would your verdict have to be?
It'd have to be not guilty.
Okay, and then what about you, number 8, Ms. Phillips? It would have to be not guilty. Would you have any issue finding somebody not guilty, even if you potentially thought something did happen?
No, because it's be black and white, so if it's not really saying, then I would think about it.
Okay, let me ask you this, if there were pieces of evidence, okay, there were some kind of suspicious facts out there, but there was no way that you could put them together that led you to beyond a reasonable doubt. So in other words, you think maybe something did happen. Is that the same thing as proof beyond a reasonable doubt in your mind?
No, you have reasonable doubt.
Right, okay, and so your verdict would be? Thank you. How about you, Mr. Mendez, number 9?
I'm gonna say not guilty.
Not guilty. And what about you, number 11? Or no, sorry, number 10, Mr. Johnson? Not guilty. What about you, number 11?
Not guilty.
Not guilty. Would you have any issue finding somebody not guilty, even if you thought maybe something did happen, but you were not at beyond a reasonable doubt?
Has to be proven.
It has to be proven. What about you? Is it Ms. Beltran?
I'm not guilty.
Not guilty. How about you, Mr. Day? What about you, Ms. Pena? And how about you, Mr. Carroll? How about you, Mr. Brown? Would you have any issue finding somebody not guilty if you thought maybe something happened, possibly something happened, but you weren't at proof beyond a reasonable doubt? No. How about you? Is it number 29?
Not guilty.
Not guilty. How about you, Ms. Madrano? Number 28?
Not guilty.
Number 27, sir? What about you?
Not guilty.
Mr. Kimmel? And how about you, is it Jose? Okay, how about you?
Not guilty.
Okay, and then what about you, Miss Amanda? How about you, Miss Ashley? And then Miss Laura? Thank you so much. Mr. Ferguson? Is there anybody that feels, if I believe that maybe something happened, even if I'm short of beyond a reasonable doubt, that because I do think something happened, I would not be able to find somebody not guilty? Is there anyone by a show of hands that feels that way? Okay, good, thank you. Oh, sorry, back here.
I always struggle with that.
Okay, Mr. Lewis,
What number is that?
number 44.
Okay, we have number 44 already.
I understand the capital murder piece, but if there was something that did not seem right, I would struggle here with the complete innocent.
I appreciate that. Does anybody else feel like Mr. Lewis, number 44? Okay, is it
Whether
Mr.
it's Mr. Mendez.
Mr. Business, number 9?
I just feel it's capital murder's murder. You took someone's life. So it's black and white on the docket, capital murder. I couldn't walk away knowing that I said innocent to somebody that took somebody else's life.
Let me ask you this, and so if you were not, given an option of a lesser included, okay? You were not given the option of a lesser included. If you were, and therefore you can only make a decision about guilt or not guilt of capital murder. Okay. Are you saying to me that if you didn't have that lesser included option and you thought maybe something happened, but you were not convinced beyond a reasonable doubt, that you would vote guilty just because you felt like something?
Black and white, yes.
That is the only thing that I'm asking. You know what I mean? Like, I don't wanna argue with you, right? Like, I think that's a really, really super honest answer, and I really appreciate
All
it.
right, Mr. Mendez, I hope you understood the question.
I believe I did, but please.
Okay, so, it's a capital murder charge, and Ms. West is asking you, if the state doesn't prove each and every element to you beyond a reasonable doubt, means you've heard all the evidence, and you believe it's not capital murder, are you telling the court that you could not find Mr. White not guilty?
Okay, then I did misunderstand. Shocker.
Because you would have to find him not guilty, even if I do charge the jury with a lesser included murder, you would have to find him not guilty on the capital murder charge. Does that make sense? Before you can
No,
even
scrambled.
consider anything else. Huh?
Said now I'm scrambled.
So that's her question. If there's not a lesser included charge in there,
If there's not,
and the state proves the capital murder to you beyond a reasonable doubt,
then it's guilty.
okay,
My
that's,
answer would be guilty.
okay.
No, my question is the opposite of that.
What was the opposite, meaning?
Meaning that, right,
Oh, they didn't prove to you, I'm sorry.
but that
Okay.
you believe something happened.
Okay, so they didn't prove it to you beyond a reasonable doubt. You have a reasonable doubt or reasonable doubts, gaps in their case, okay, that would have helped you come to a conclusion.
In capital murder.
A capital murder,
Yes.
right.
Yes, I
So
get that.
if that's the position, they didn't prove their case beyond a reasonable doubt, and you feel in your heart that maybe if you had some other information that maybe you would have gotten, could you find Mr. White not guilty? Or would you convict him just based on your feelings about what else could have been out
In the aspect of capital murder, no.
there? No, meaning what?
Meaning I could not convict. I cannot say guilty
Okay,
in the aspect of capital murder.
okay, and that's what she's asking you. Ms. West, do you wanna, you can clarify some more if you want.
Okay, no, I'm not gonna clarify it anymore because I think everybody's sufficiently confused. Okay, so again, at the end of the day, what I'm trying to judge and assess here is whether or not everybody understands the difference between proof beyond a reasonable doubt and whether you think something maybe happened, probably happened, could have happened, and that is a different standard than beyond a reasonable doubt. And it sounds like everybody understands that. Okay. Is there anybody here, when you're understanding remuneration, that believes that you can make an agreement to do something after the act is done? Is there anyone that thinks, well, no, like after the fact, if you go backwards in time, then that's fine? Does anybody agree with that? So ultimately, like if there's evidence that some conversation about killing somebody occurred after that person was dead, would that be evidence of remuneration or the promise of remuneration for anybody in this courtroom? Nobody? Does everybody understand what I'm saying? Because it could be that maybe not. Is it Mr. 52, Mr. Tips? Yes, sir.
I think it'd be, the context of the conversation would be the barometer for me.
Okay.
Because if the conversation happened in person initially, there'd be no record of it. If that is then referenced
Okay,
Does that make sense?
it does. Does anybody else agree with Mr. Tips, number 52? That if there's some conversation after the fact, and then maybe a text or something exists.
Acknowledging a prior conversation that both parties seem to be aware of. There's not, what are you talking about? There's not, I never said that, you're making that up, that kind of thing, but there's a conversation about previous conversation that no one's objecting to. Just because we don't have the prior text message because it's in person doesn't disqualify. Does that make sense?
It does, I understand what you're saying, and so obviously you're saying if there's like a general acknowledgement on the back end about something that already took place. What if there's not a general acknowledgement on the back end that's something else? What if one person is saying, I don't know what you're talking about, or not being responsive, or whatever?
Yeah, I mean, then it's subjective.
Then it's subjective.
One person's saying a conversation happened, but the other's denying it, then it's he said, she said.
Okay. And how do you make decisions about things that are he said, she said?
I mean, that wouldn't be proof beyond a reasonable doubt.
Is there anybody else that agrees with Mr. Tips, number 40? No, 52. Okay, is it Ms. Nunez? What are your thoughts about that?
I just agree with you.
You agree?
I just agree with you.
Okay, was there another person that had their hand? Is it Ms. Conklin? Yes, ma'am.
Yeah, I mean, he said, she said is not reasonable doubt.
Is not proof beyond a reasonable doubt?
Yeah.
Okay. Does anybody else feel that way? That he said, she said is not proof beyond reasonable doubt? Is it Miss?
Let's have their number.
What's your number, ma'am? 62. Yes, ma'am. What are your thoughts?
he said, she said is not proof beyond reasonable doubt.
And so if you have evidence of he said, she said, but not a confirmed conversation where everybody's acknowledging, then what would that mean for you?
There's reasonable doubt there, and that would not add up to remuneration.
I know, we have all been practicing remuneration. Okay, so is there anyone else that feels any differently about that? Does everybody agree that remuneration requires some kind of agreement before an act occurs? Is there anyone that says, no, that's not required? You do not have to have any kind of discussion or agreement as it relates to remuneration before an act occurs?
I just have a question.
Yes, ma'am. Is it number 35?
Yes.
Yes.
So are we talking about we don't have evidence that happened before? And that's because I guess so remuneration requires conversation before. But in the example is that we have evidence that a conversation happened after. And the idea is that it's suggested that a conversation may have happened before and we don't have evidence for that? That's the question?
Yes.
That's a little confusing, what you just said. I think what the gentleman in the back was saying is that even if there's not an agreement that was made, you know, if the way I understood it, okay, if the state can't provide evidence of a payment or an agreement before the offense happened, but there's a text messaging between the parties after the fact, okay, acknowledging that yes, there was an agreement made, then that's proof that there was an agreement for remuneration. Does that?
And that makes sense, yes.
Right.
So, okay, agree, yes, that would be proof. I guess the clarification question is, I thought in the example that we had, the conversation that happened after the fact, there was no mention of a prior.
Okay, and these are hypotheticals, okay?
Sure, yeah, I just wanna, because I'm a bit of an overthinker, if that's not clear.
That's good.
And so, it's hard to pin down an answer on kind
No, but you did understand it, right? Like, I'm asking you that if you don't have evidence of a conversation that took place before an action, right? Maybe you have some kind of discussion after the fact, but that's not evidence of something that took place before, right?
Like in the example you gave,
Correct,
you didn't know your ex-husband was already dead.
right.
And you talked to somebody and wanted.
And maybe there was a discussion about how I was happy about the fact that he was dead.
Okay.
I may have given somebody a bonus
Yeah.
for killing him. Does that make
But
me,
it wasn't planned beforehand
right,
by you.
and so does that make me guilty of capital murder? And if I'm the shooter, okay, if I'm the one that did the killing, and then I have a conversation, you know, with the ex-wife of the person, right, so I'm the shooter now, you're with me, and I say, man, thank you so much for killing my ex-husband, I'd like to buy you a bag, I'd like to give you some money.
It's not capital murder.
It's not capital murder, right? Does anybody disagree with that? No, okay, it all makes sense. I'm gonna go with it makes sense to everybody. And so everybody agrees that you know, for remuneration or the promise of remuneration has to be before. We all agree with that. Is that right? Okay. There's a lot. Okay. Let me ask everybody this. Why is this lady crying? Give me some reasons why she might be crying. Number 7.
Loss of her dog.
How about number 8? 9?
Toothache.
Toothache. It does hurt. Number 10.
Loved one.
Number 11.
She got injured?
It could be anything, right?
Yeah.
And you don't know. But you do have this picture. And you do, I mean, it could be something happy. She could be crying because she's happy about something, right? It doesn't have to be something sad, right? Is it appropriate to make assumptions about why this woman is crying?
No.
And so if you're chosen to sit on this jury and the court asks you, or not the court, I'm sorry, the state asks you to make assumptions about why something occurred, is that appropriate? Would that be appropriate to make an assumption when you have just a picture with no context? Would anybody here say, okay, but I think it's reasonable, in the picture she kind of looks sad, she's probably crying about something sad. But you don't know. So is anybody going to lower the state's burden and say, even though I don't know, even though I don't have evidence of it, I'm okay with saying she's crying, she's probably sad, and I'll fill in those gaps? Is there anyone that's willing to do that? Okay. I want to talk a little bit about the grand jury process. Who has heard of an indictment? By show of hands. I'm going to ask, is it Mr. Kyle? Have you heard of an indictment?
I have.
What is an indictment?
I think when prosecutors are gonna bring a charge against someone,
Do you know how to get to an indictment?
through a grand jury, I believe.
Through a grand jury. Does somebody have to be investigated, usually, by police? Is that fair?
Yes.
Do arrest warrants have to go be presented to a judge?
Yes.
Is that usually how it happens?
I think so, yes.
And then maybe somebody's arrested, is that right?
Yeah.
And then ultimately, maybe somebody's case or accusation is taken to a grand jury, is that right?
Correct.
And then it moves forward, is that your understanding?
It is.
And so does everybody understand that simply because somebody has been indicted, charged, arrested, accused of something, that's no evidence of guilt? Is there anyone here that says, well, because this is a really serious offense, capital murder, and because Mr. White is sitting here in this courtroom charged with capital murder, he must have done something. He must be guilty of something. Is there anyone here that feels that way? That's really great. Okay. Is there anyone that is going to say to themselves, Mr. White has been charged with a serious offense, and even though I understand the presumption of innocence, I just don't I just don't think that I could presume him innocent when I know that he's been charged with something so serious. Is there anyone that feels that way? By a show of hands. What if if I'm the prosecutor, and I've decided
Judge,
that,
I'm gonna object. May we approach?
Yes, you may.
may I continue?
Yes, you may.
Okay, so, what I think is important for everybody to understand is that what we talked about is the standard way that a case can get indicted. I think we all agree that that's not any evidence of guilt, right? But there are other ways that cases can get indicted that don't go through an affidavit process, presented to a judge process, presented to and then presented to a grand jury. There are another process called a grand jury referral, which is just where the government can present information to a grand jury and seek an indictment. Does everybody understand what I'm saying? If a case is indicted through that second process, through the process of just, a prosecutor being able to go to a grand jury and present information and get an indictment. If that's the process by which a case becomes an indictment.
Judge, I'm gonna renew my objection.
Your objection is sustained. Ms. West, an indictment is an indictment, and just limit your comments to the fact that there's an indictment in this case.
And so there's nobody here that's gonna say because there's an indictment, I'm gonna find somebody guilty. Is that right? No? Oh, wow. Mr. Mendez, number 9, do you have any issue with that?
Please repeat.
Because somebody's indicted and they've been charged and an offense is serious, that you believe that they must have done something, and so you're more likely to find them guilty of whatever they're accused of. Thank you so much. It's really important that we understand exactly what the government is charged with proving. There's really multiple things here that each have to be proven beyond a reasonable doubt. So obviously that the defendant is the defendant, that the defendant killed a person, that the defendant was paid or promised payment, and the defendant was promised payment, and that payment came from a specific person. Those are the 4 things that have to be proven under the type of indictment that is pending in this case. So what I want to ask you is, let's say you have evidence, if you believe beyond a reasonable doubt, that the defendant is the defendant, that defendant killed someone, that defendant was paid or there was a promise of payment, and you believe all those things beyond a reasonable doubt. But you do not believe beyond a reasonable doubt the person that paid or was promised to pay. Okay? The state has alleged a specific person paid or promised to pay in this case. So my question to you is, if you believe that it was the defendant, that he did kill someone, that he was promised to be paid, or in fact paid, but the person that they're saying did the payment, you do not believe it was that person. You do not believe that you have been given enough information to believe beyond a reasonable doubt that it was that person. Is everybody with me? If you do not believe that it was that person, what would your verdict have to be? Is there anyone that says, okay, but Ms. West, I believe that it was the defendant, I believe that he killed someone, I believe that he was paid or there was a promise to be paid. So the fact that I don't believe that the person they're saying did it is not the person that paid him, I believe everything else. So I think it's fine to find him guilty of capital murder. Is there anyone that believes that? Okay, yes ma'am. Is number, yes ma'am.
Maybe I'm misunderstanding, I'm not sure. So, what I'm not understanding is how would you believe beyond reasonable doubt that the person was paid before, you know, in
Yeah, all the
compensation for, yeah,
Yeah.
if you didn't know who, I guess, if you didn't know who from, I guess, does that make sense? So like,
But what if you don't?
well, then you, if you don't know who, then how would you know that that conversation happened before the murder?
Let's say you have evidence that somebody was paid. Maybe they have money, maybe they're spending money, maybe they're talking about money, but you don't have any evidence of who gave them that money.
I don't know, to me that still sounds like, if you know that this person accepted money for a murder, and they had an agreement from beforehand, that's capital murder.
But, okay, in this case, they're alleging a very specific person paid or promised to pay. Okay? So that is an element that the state has to prove beyond a reasonable doubt. In addition to proving that there was either a payment or a promise to pay, in addition to somebody being killed, in addition to the defendant doing it, they also have to prove beyond a reasonable doubt that a specific person, not just like they got paid, right? Not just like there was a promise out there to pay them, but there has to be proof beyond a reasonable doubt that a specific person did it. Are you following me?
Yes, I'm just trying to think of what my answer would be, because I feel like I don't know how you could have one without I don't know how you could be sure without knowing. Because if they present a case, like in your example, whoever did it would have received money from you or a handbag or whatever after the fact. But you didn't have a conversation beforehand, so how?
So and maybe the confusion is you think I'm building off of the example that I
No,
gave.
I'm not, I'm just
Okay.
trying to use that as
Okay,
that as
okay.
a-
So in this,
In my brain, if so, or I guess from what, not that I know anything about capital murder before this is all education for me, but what I'm understanding from what we've all talked about is that you have to, you have to have talked about that beforehand, right? The
there has to be an agreement beforehand.
There's the defendant did it, there's a murder, all of that.
Yes.
So I don't.
All right, Ms. Ruback?
Yes.
So I think what Ms. West is asking is, you know, the state in this case has alleged that a specific person paid to have this murder committed. And so the state has to prove that this particular person was the one who made payment. Ms. West, is that what you're asking?
Yes.
Do you understand? So if they can't prove to you that this person that they are saying is the one that made the payment for this murder, then your verdict would have to be not guilty.
Not yet, the person who they said paid is not guilty, but the person who did the murder, see, that's what, the question is the person who did the.
The person who committed the murder.
Yes.
They're
So
saying,
I think I understand the question, I
yeah,
just
she's
don't think I'm
saying
getting the answer that is
if the state
expected
can't
from me.
prove, if the state can't prove to you that the person, you know, the state's alleging made the payments, let's say Ms. West is the killer.
Yeah.
Okay? And made the payment. Okay?
Okay.
If the state can't prove to you that did I say Harris?
Yes.
I'm sorry, Marissa. If the state can't prove that Marissa made the payment, then your verdict should be not guilty. That's what Ms. West is trying to tell you.
Okay.
The state is alleging that Marissa paid Ms. West to do the killing. But the state cannot prove that Marissa made the payment. Am I getting everybody confused?
So this is like the situation we were talking about before, but it's a step up. So when we're talking about there's murder, but it wasn't capital murder, so can I convict him of capital murder? Obviously, the answer is not guilty. But in this case, there was capital murder, we just don't know who made the payment, and so we're supposed to say not guilty because we don't know who paid.
Yeah, I have a problem with that.
There we go.
Listen,
We got there.
I understood it, I just don't.
Right.
No, and wait, pause right there. You understood it, but you just don't like it.
Yeah.
And that's my question, okay? Because the law is, if this is how they charge someone, and they cannot meet your standard of proof beyond a reasonable doubt for the person who paid, then that is a required element for the state of Texas. And so if they cannot prove it, then the law requires you to find somebody not guilty. The difficulty in that is that you do believe that a defendant killed someone and that they were paid for it. But an element is missing, which is required by the state. So my question is, in that type of scenario, understanding that your verdict would have to be not guilty,
Yeah.
if you were chosen to sit on this jury, would you be able to do that?
Because it's the law, yes, it would be hard for me too, though. But I did, coming into this not knowing that, it would be difficult for me, but I would do it.
Okay, so my question is, I understand that it would be difficult, I think that it would be difficult,
Yeah.
I think that's a normal feeling to have, right? But my question, and it's not so much like I would try, right? But it can't be that I would try.
Yeah.
Because if you were chosen to sit on this jury, it's beyond I can try to do this. You have to be able to sit here and tell us that if I don't have evidence of the person that paid, then my obligation is that I have to vote not guilty. And are you saying yes you can?
Yes.
Okay. Is there anyone else that says I'm not comfortable with that?
Okay, now, a lot of people will not be comfortable with that. Correct. But remember, you are not saying that this individual did not commit a killing or a murder.
Right.
Does everybody understand? Ms. West is asking you about capital murder. And if there's a lesser included offense that comes through the testimony, I will instruct you on that. Does everybody understand?
Yes.
So let's not get confused, okay? If the state cannot prove that there was remuneration, or they can't prove the person who made the remuneration, you're talking about capital murder. Okay, and the law says that you will find the defendant not guilty of what?
Capital murder.
Capital murder. Okay, that's the law. And if you can't follow it, then you won't be a good juror for this case.
And that's what I'm trying to get at. Because this is about, if you were chosen, you can't be asked to go against your own conscience. You can't be asked to do something that you're not comfortable doing. And so no, nobody's comfortable with it. But some people feel so strongly about it that if they were chosen to sit on this jury, they could not.
You have 15 more minutes, Councilman.
Thank you. And that's what I'm asking.
I could not.
You could not. Thank you.
You could, I'm sorry, hold on. You could not do what?
I could not render a non-guilty for capital murder if that was the case. If that one element was left out. But I thought the reasonable doubt was for the doctor.
Right.
I could not do it.
Right. And I
And that's
appreciate
your number
69.
69. Okay, we already have you there.
Number 9.
Number 9, Mr. Mendez.
Yes, ma'am.
Thank you, sir.
Okay.
Anyone else, number 15? Thank you very much. I think I just saw you.
15 we already have.
Okay. Are you number 59? Okay. Were you going to say no, you can't? Okay, we have you. Thank you so much. 58, okay, I think we
Hold
got.
on, let's slow down a bit,
Oh.
okay? So that was, 59, we already have, 58, we already have.
Right.
Okay.
Number 57, Ms. Harvey.
Can you speak up just a little bit, ma'am? Because I can barely hear you.
I'm taking care of my child, 7 years old, so I have my excuse.
And so you have,
She has an excuse.
She's using her child exemption.
oh, I see, you have a 7-year-old child?
Yes.
And you're the only one who supervises her?
Yes.
Okay. Who has her now?
She is in school and then with my friend.
Okay. And then daycare?
No.
A friend.
Okay, okay, well, thank you very much.
Okay, over here, did I see any hands over here?
I had a question. So,
Are you number 31?
yes.
Okay, yes.
So what we're saying is, if it's proven without a shadow, or without a,
Beyond reasonable doubt.
beyond reasonable doubt, sorry to confuse you with that earlier, that murder was committed, payment was made for the murder, all the elements for capital murder, the only thing is the identity of the payer is not proven.
Correct.
And the only option is guilty or not guilty.
Correct.
Okay, now,
Because
that's, sounds like it's, that's beyond, defenses or the state's, purview to say that would be the only option. Remember, I told you all that I am the lawgiver in this case, okay? You are the fact finders. So if the state is able or not able to make all the elements of the bigger offense of capital murder, and the evidence shows that yes, indeed there was a killing, it's just that the element of the remuneration is missing, then I may charge you with the lesser included offense of murder. Does everybody understand?
Yes.
I'm not saying that's going to happen because it may be that the state just can't prove that Mr. White killed anybody. I don't know, okay? But if they prove that Mr. White killed somebody, but they cannot make the element of the remuneration, the payment, then there will be a lesser included offense, if the facts show it. And so you would have to find him not guilty of capital murder. Does everybody understand?
Yes.
Okay. Go ahead, Ms. Rose.
Did that address what you were asking though?
Mainly, yeah. Like, I guess it came down to it, like, everything proved it except for that one little piece, and the only other option was not guilty, then I would have a problem. But if there was, as the judge,
But I guess I'm qualifying you on your ability to deal with capital murder as an offense. The judge is saying, like, maybe there will be a scenario where there will be a lesser included.
And maybe not.
And maybe not. So I have to be able to know that if there's not, and your only options are in fact guilty or not guilty of capital murder, and one of the state's required elements is not proven beyond a reasonable doubt, that you understand that you would have to find the defendant not guilty. That's what the law would require.
Your
of
Honor,
capital
I'm gonna
murder.
object, because under this hypothetical, there would be, like, part of this hypothetical is assuming that the state has proven up the lesser included offense. And so I think it's misleading the jury or the panel and creating some confusion on the fact of, under this hypothetical, it walks them through and says, you have to find him not guilty, but in fact, we're leaving out the fact that you would have, under this hypothetical, an instruction on a lesser included offense of murder, from which then they could vote guilty or not guilty based off of this hypothetical.
Correct.
And I just asked for that, okay, thank you, Your Honor.
Okay.
So let's not confuse the jurors further. If the state, proves that there's a killing, that Mr. White killed somebody, but there's the missing element of the payment or the promise of the payment, then I will instruct you on the lesser charge, okay? Which is murder. So you would have to find him not guilty of capital murder, and you would have to go to murder and consider that. Does everybody understand?
Yes.
Okay, but if the state doesn't prove either capital murder or murder, you would have to find him not guilty, period. Does everybody understand?
Yes.
Okay, and that's why you have to listen carefully to the evidence, all right? Go ahead, Ms. Chris.
Okay. Any other questions? Does anybody else have questions about kind of how this process would work? You believe all of these other things, a required element by the state is not proven, you could not find the law wouldn't allow you to find them guilty of capital murder. Does anybody have an issue with that? Who else? Okay, and then I want to just double check with you, Ms. Villa, number one. Any issues kind of following everything that we've been talking about?
I understand most of it.
Okay,
Not familiar with all the law and all that stuff, but I pretty much.
if you were chosen to sit on this jury, would you have difficulty following whatever's being, it's gonna be law stuff or legal words?
Well, nobody expects the panel to be lawyers or legal advocates, okay? So any law that, comes forth, I will explain it to you in the court's charge. So even if you're not a lawyer and you don't understand every legal term that's being said here, that does not disqualify you as a juror. Does everybody understand?
Yes.
Okay, so if you're following along the discussion and you think you'll be able to sit here in these comfortable chairs and follow through with the evidence, that's all we need, and be a fair juror. I will give you the law in the court's charge that you will take back to the jury room and discuss with your fellow jurors and understand it, and then render a verdict, okay? Go ahead, Ms. West.
Thank you, and then how about you, number 49? Are you following everything and understanding everything that we're talking about here?
Halfway.
Okay, because at the end of the day, it's important that you understand everything that's going on to ensure that this process is fair to both sides. So if you're saying that you're only understanding some parts of what we're discussing, that's important to know.
Yes, some words that I might not be able to understand very clearly.
Okay, and
Yeah,
so,
I have 49 down for English comprehension.
Oh, okay.
Yes.
Judge, do you have 27
27, let's see. Yes, I do.
and 56?
56, yes.
Okay.
But I do have a question mark, 56. Ms. Velasquez?
Yes.
Could you raise your hands, please? Oh, Mr. Velasquez. Renee Velasquez, yes. Mr. Velasquez, have you understood everything that's happened so far? All the discussion?
Most of it,
Most of it?
yeah.
What parts didn't you understand?
I read the process in some of them.
The process?
And some of the language?
Yeah.
Some of the language?
Yeah.
Okay, you mean the legal language? Well, let me ask you this. If you were chosen as a juror, with what you've heard so far, do you think you'll be able to listen to the evidence and be able to understand what's being said?
Not everything.
Okay, thank you very much, and I have you down.
Okay. And I think I only have a few more minutes. So, is there anybody here, it's very normal when you're charged with a serious offense, if you were chosen to be a juror, to want to hear from both sides, or want the defense to do something, to be able to either disprove something or explain something or whatever. But you understand that the law says that that is not how our justice system works, and there's absolutely nothing that the defense has to do other than show up today. But it is normal to say, me personally, I don't know that I would be able to make a decision if I did not hear from both sides, or that I did not hear something from the defense. That's you personally. Is there anyone that feels that way? Is there anyone that says, I would really need to hear from both sides in order to make a decision about something? Anybody over here in the back?
We have number 59. We already have you down, sir.
Yes. Anybody else feel like 59? Number 19. Mr. DePetris? I think I have.
I have you down.
Okay.
Yes, and what Ms. West is asking for, but she wants to, ask you from the defense point of view. Remember we said that the burden, the entire burden in a criminal trial rests on the state to prove each and every element to you beyond a reasonable doubt. You all remember that?
Yes.
And that the defense does not have to bring forth evidence, right? Okay, so that's what she's asking you. Can you follow the law? Or do you require Mr. White to testify? If you do, you will not be a good juror, a fair juror for this process, okay? So, can you follow the law? Go ahead, Ms. West.
And how about you, is it number 50, Mr. Segovia? Obviously, I think it's natural, I don't know if this is true for you, it's natural for people to want to hear from both sides. Would you agree with me?
Yes.
Okay, and if you were chosen, what are your thoughts about that?
Just that it would be fair to hear from both sides, square from both sides.
Okay, and what if you did not hear a story from both sides if you were chosen to sit on this jury?
You mean from the defense?
From the defense.
Right.
I mean, obviously, you naturally have to hear from the state.
And what was your question?
If you don't hear anything from the defense, in this case, if you were chosen to sit on this jury, is that, how would you feel about not hearing anything from the defense?
Fair.
It would not be fair? And who would it not be fair to? No, what I'm asking you is if, as the defense, if we don't do anything in this trial, other than just show up, we don't.
Explain the law to me first of all.
Right.
Ms. West,
So,
Ms. West,
yes,
explain the law to him first.
okay. So you understand that under, the way that our justice system works, right, is a defendant has a right not to testify, not to do anything other than show up if they're accused of a crime and not do anything else. They're not required to prove their innocence, they're not required to show anything. Do you understand that? That's how our law is set up. Do you have any questions about that? Oh, do you understand that?
Yeah.
Okay. And my question to you, understanding that that's how the law works, if you were chosen to sit on this jury and we as the defense don't do anything, we don't, Mr. White doesn't testify, we don't offer alternative theories, we don't offer any explanations, if we don't do anything other than show up each day, would you have any issue with the fact that we're not doing anything? Or would you be able to listen to the facts and the evidence and make a decision about whether or not the state has met its burden of proof beyond a reasonable doubt?
I think the question is, would he hold it against the defendant, or would he be biased against the defendant, not whether he would have a problem with that?
Did you understand the judge's question?
Yes.
Okay.
So, Mr. Segovia, would you hold it against the defendant, or would you hold the state to their burden? They're the ones who are supposed to prove that he's guilty beyond a reasonable doubt. If he doesn't testify, if the defense doesn't testify or bring forward any evidence, could you focus on what the state brings you and be able to base your judgment on that and not hold it against the defendant?
Me personally, I would love to hear both sides of the story.
Okay, would you hold it against the defendant if he does not testify? That's the thing. Would you feel he must have done something, or would you be biased against him?
I feel like there should be a reason why he wouldn't.
Okay, the question to you, sir, is would you hold it against the defendant if he doesn't testify?
Yes.
Thank you.
Anybody else feel like number 50? Just by show of hands. How about over here?
We have a hand over here. That's 25?
25, yes, sir. I think we
Yes, we already have
had
25.
you down. Any other hands? Is it, number 67,
Sensabaugh?
Sensabaugh?
Sensabaugh.
Yes, sir. Okay, so you've been following everything that we've talked about here today.
Yes, ma'am.
And you understand, sort of that, exactly what the judge was just talking about, that the law does not require the defendant to do anything in this case, you understand that?
Yes, ma'am.
And if in a case like this, which is a charge of capital murder, if you were chosen to sit on this jury, would you hold it against us? Would you hold it against the defendant, or would you have any sort of bias against the defendant if, like, number 50, we didn't do anything? We didn't offer you anything, we didn't testify, we didn't offer alternative theories, nothing. Would you hold it against us or have any sort of bias?
No, ma'am, I would presume that the defense is innocent until given evidence beyond a reasonable doubt otherwise.
And that presumption of innocence, you'd agree with me, starts right now, right? And carries all the way through the entire trial. At no point does that cloak of innocence come off unless and until at the end of the trial, after everything's over and you're deliberating, can you even think about taking that cloak off? Do you understand that?
Yes, ma'am.
Is that something that you can do?
Yes, ma'am.
Thank you so much. Does anybody have questions about the cloak, sort of this presumption of innocence? And so my last question for you guys is, by show of hands, has anybody ever been a victim of crime? Is it number 2, Mr. Ray?
I'm on the list, I think.
You're already on the list? Okay. Has anybody else been a victim of crime? Is it number 64, Miss?
It does not cloud my judgment.
Say it one more time?
It does not cloud my judgment.
Okay, but you have been a victim of crime. Is there, if you, I don't want you to give specifics of your personal situation, but was it, was it an assaulted crime? Was it a property crime? Assault, okay. I appreciate that. Thank you, and I don't want to get into your personal business. Anybody else? Victim of crime. Is it number 12, Miss Beltran? What, without having to go into detail, a violent crime, assaulted crime, a property crime? Assault, okay. Is there anything about that experience that, might be in the back of your mind or might, come into your mind if you were chosen to sit on this jury? Okay, I appreciate that. Anybody else? Yes, sir. We were just talking. I'm glad I asked this question. Number 67, yes, sir.
It's just a theft.
Okay, you were the victim of theft? Okay, is there anything about that experience that would, did they catch the person that stole from you?
No, I don't think we even made a police report. We just had our lawnmower stolen.
Okay, okay. So anything about that experience that would make it difficult for you to listen to the facts and the evidence in this case?
No, ma'am.
Okay. Any other victims of crime?
It's 31.
31, yes, sir. Number 31. You've been a victim of crime.
I don't think it would affect my, it wouldn't affect this case, but I have
Okay.
had
And
robbed.
you've been robbed before?
Yeah.
Okay. So in other words, you've had sort of a violent crime committed against you. Is that a fair statement? I mean, I would say robbery is a violent crime.
I mean, there was no violence, but someone took a gun and said, give me your money.
Okay. Okay. And so you're saying that there's not anything about that if you were chosen to sit on, did they ever touch the person?
I don't think so.
Okay.
I mean, it was a long time ago. It's not like a fresh trauma or something.
Sure, absolutely, I get that. Thank you. Thank you for sharing that though, and I'm sorry that happened. Is it number 34?
34, yeah.
Yes, sir.
I've had the same thing. I was robbed at gunpoint.
Okay. Were you able, did you call police and
Yeah.
try to pursue a police report? They never found him? Okay, and so is there anything or something about that experience that if you were chosen to sit on this jury, potentially, is in the back of your mind? Not really?
No.
Okay, no? Okay, thank you. Anybody else? Victim of crime? Is it?
One more minute, counsel.
Thank you. Is it number 17? Have you sort of followed everything that we've been talking about here? Do you have it? Sorry, say it one more time. to some extent. Okay, and so obviously, if you were to be chosen to sit on this jury, you would have to listen to the things that were going on in the courtroom and follow what's going on. Would you have any difficulty doing that based on you're only following some of it now?
Yeah. I mean, some of the pieces must have.
I can barely hear you, ma'am. Sorry, can you speak up a little bit?
No, what I'm saying is some of the languages, the no languages, not familiar for me, so I cannot catch up to everything.
I still can't hear.
She said that, some
Very
of the.
soft-spoken.
Yes, some of the language is very difficult for her to catch and comprehend.
Is it some of the legal language that we're
Yes.
using? Okay, well, then you're not a lawyer, so, but are you following, with the language that's not necessarily legal?
Yeah.
Yes?
Yes, you are following, or no, you're not following?
I'm following.
You're following. Okay, and if you were chosen to sit on this jury, would you be able to listen to what's going on in the courtroom, understand it, process it, and make a decision? She says it's difficult for her.
Okay. All right, thank you.
Thank you so much for that. I think that I'm out of time, so I very much appreciate everybody keeping focused with me. We were having to talk about a lot of different difficult things, so I appreciate that. And I look forward to working with the 12 of you that will end up on this jury. Thank you.
All right, thank you, Ms. West. Ladies and gentlemen, we're going to take a break, about 20 minutes or so. Hopefully, it might be a little less, but it may be a little longer. So, use the restroom if you need to, and be back in the hallway at about 4:30. the same. I'm going to administer the oath to you, to impanel you, and you will remain under my instructions, same instructions that I gave during the voir dire, especially now, more so now. You are not to listen to anything on the news about this case, or do any sort of research on Mr. White or his attorneys or the state or anybody else in here. You can't talk to each other. You can't even talk to your spouse, okay? To your children, your friends, coworkers, anybody about what's going on here. We want you to remain open and unbiased, just like you promised to do, and concentrate, focus on what you hear from the witness stand, okay? So that's going to be my ongoing instruction throughout the process. Please dress in layers. Sometimes it gets really cold in here. Sometimes it gets really hot in here. So you want to be able to, be comfortable. Bring your own beverages. Lunch will be in our 5-star cafeteria every day. During COVID, a long time ago, it used to be that the county would provide, the lunch for the kids. They don't do that anymore, so, we're all stuck with that cafeteria downstairs. And so, tomorrow morning, we're going to start at 9 a.m. sharp. Traffic gets a bit crazy down here, or difficult, so please start out early. Okay, start out early, so you will be here at 9 o'clock. Okay, my bailiff wants me to tell you to be here at 8:30, so that, y'all will be present and we can start right up at 9, okay? It's a logistical issue, okay? So.
I was gonna ask if we could bring our own lunch.
Yeah. Absolutely, absolutely. Bring your own lunch, your own beverage, whatever makes you comfortable to eat, except alcohol.
So, to confirm, it's Monday through Friday, 9
Monday
a.m.
through Friday, yes.
For the next 2
Not
weeks.
Saturdays or
For
Sundays.
the next 2 weeks.
For the next 2 weeks, okay? Yes,
And
ma'am.
will we be here this late?
No, no. This was just, it was just for this process. Usually, I will let you all go right around between 4:30 and 5, okay? Okay. All right. If you would raise your right hands for me, everybody. Do you and each of you solemnly swear or affirm that in the case of the state of Texas versus Kimon Dontrell White, you will a true verdict render according to the law and the evidence, so help you God?
I do.
Thank you very much. Now, my bailiff will take you back to the jury room where you will meet each day, and he will tell you how to get here, okay? So I will see you tomorrow at 9 a.m. Thank you very much.
Thank you.
All right.